For judgment, item 1, retable 7 of 21, matter pertaining to Itanagar bench.
Brother, pronounce the judgment. You may pronounce the judgment, brother.
Yes, my lord. Consequently, the impugned judgment and order dated 24/11/2020 passed by the learned single judge stands satisfied and passed. However, taking note of the fact that after passing of the impugned order, the government has already released the pension of the respondent petitioner and he is getting his monthly pension, we think it proper to direct the appellants herein to continue the payment of monthly pension to the respondent petitioner. However, the said payment would remain subject to any decision taken by the competent authority under Rule 9, Sub-Rule 1 of the CCS Pension Rules 1972 after conclusion of the criminal proceedings initiated against the respondent petitioner. The petition stands disposed of with the above direction.
Deeply obliged. For pronouncement of judgment, item 25 to 28.
Consequently, we allow these present appeals. The impugned order dated 6/7/2022 passed by the tribunal in ITA case number so and so is set aside, and the orders passed by the CITA dated so and so are affirmed.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 14. From item number 19 to 24.
May I please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 22.
22.
22, lordship.
Chair, Chair.
Not hearing anything, turn up volume.
May I please, your lordship, I beg to mention item number 21. Can it be taken after puja vacation? We have taken the consent from the other side.
Turn up.
Chair, that is the
Question again? Sound up.
May I please, your lordship, we are for listing a fresh readable lordship on 27th.
Any other request? Daily list for admission, item 1.
Sorry. My lord, we have challenged certain portion of the Assam Prosecution of Services Rules 2023. It was received yesterday before under single judge, but it was discovered that it relates to division bench. So this matter may kindly be listed tomorrow. My lord.
not tomorrow. Tomorrow we have already 30th. 30th. Yes.
May it please, your lordship. Lordship, there is a matter of urgency in this writ appeal. Lordship, can it be fixed on Thursday? Lordship?
Why? What's the urgency?
Lordship, the appellant is without service for several years, even after
No,
years.
service was several years, so one day or 2
Lordship.
day, what would happen in that?
Lordship, if it can be listed on Thursday, your lordship.
No, no, the next 30th day of the first.
For admission, item 1.
He is on the number 226. Okay, 5 minutes. It should be 227. It should be 227. It was fine. But- Will be extended as comfortable. And another thing on minutes, what we learn in this is a preliminary. You can always actually go with a fact here, where is what it is different with the. Decide this.
Yes, Mr.
My lord,
How this intra-court appeal is maintainable?
that is the whole issue before my lord.
No. How this intra-court appeal is maintainable? Since the Lalit Singhal judge has adjudicated the matter from the labor court, that is the tribunal, industrial tribunal.
Okay.
So essentially he has exercised jurisdiction by Article 227. So writ of certiorari before the Lalit Singhal judge.
The application, the REIT application that was referred under Article 226.
You may mention Article 226.
Yes, yes.
27 or whatever, it doesn't matter.
Okay.
The nature of the proceedings before the Lalit Singhal judge. That is under the superintendent's power, 227. Against which our intra-court appeal is maintained.
That's an issue.
It's an issue you have to address on that.
May take some time in order to say, I'm sure we are not.
This intra-court appeal is preferred by. Appellants. Approved with the judgment dated 20th of June 2011, passed by the Lalit Singhal judge with petition number 6399 of 2017. The said petition, the order passed by the Industrial Tribunal Dibrugarh was under Chennai. We are of the run of this, we are of the view that the Lalit Singhal judge deciding the writ petition was exercising jurisdiction under Article 227 of the Constitution of India. In such circumstances, the present appeal referred against the order of the Lalit Singhal judge in our prima facie is not maintained. Lalit consent for the appellant pays some time to satisfy this court regarding the maintainability of this intra-court appeal. Time period for this granted. Yes, Tom.
And also, 24th or 25th October after opening. 24th.
25th.
Deeply obliged.
Supplementary list 29.
Yes,
Lord, the learned single judge while passing the order, showed that there was no clarity about the status of the land.
Status of the land. And that's why only the learned single judge has said before taking initiating any action, the forest authorities in consultation with the revenue authorities will ascertain the status of the land and then only proceed further.
Well, if that is done, then there is no issue.
That the learned single
But that is, Maladi, my response submission. That particular observation of the learned single judge is diluted by the first two lines above.
yeah, just show us,
Therefore, probably the department is now doing otherwise.
you just show us from this order.
Should I take your lordship directly to paragraph 3?
Fine.
At page 57?
Yeah.
This court, taking into account that no rights can be created or accrued in a reserve forest or proposed reserve forest, is of the opinion that there is no illegality in the notice dated 6/12/2017. This is a very positive finding recorded by the learned single judge.
Next,
Then lordship will kindly see. Be that as it may, it is made clear that the forest authority can only exercise such jurisdiction in the reserve forest or proposed reserve forest lands and not in respect to other revenue lands. In such revenue lands, it would be the jurisdiction of the district administration. Therefore, any action taken by the forest official has to be in consultation with the revenue authority.
next,
Now, my lord, since the learned single judge has already held that the notice issued by the forest department has
that is.
not illegal, is
that-
not illegal.
Whatever it may be, this finding of the learned single judge is diluted by the further observations, be that as it may.
Well, but then the authorities, they are construing it, otherwise they are issuing without taking Action.
Where is the notice, impugned notice?
input notice here in this case was, lordship will see one of the notices. At page 239. Page 239, lordship will kindly peruse. There are few others also, but it is also there. This is one of them.
339.
Yes. It is hereby informed the general public that who have illegally occupied the land of reserve forest
Who have illegally occupied the land
Yes.
of reserve forest.
Or proposed it.
Reverse floor by constructing Delhi, they are directed to reduce, let the forest control to make the forest land completely free, otherwise appropriate action from. So it is in relation to only that land.
Yes, my lord, it is general notice. General notice in
notice.
respect of forest or proposed forest land.
That's all.
We are in a revenue village there.
That's why only the learned single judges said. There is a prayer made in the retail land measuring about so and so, so should be settled in the, it is in the opinion, the existing allotment and settlement of the said made by individual respective application before it is appointed the petitioner respective application seeking allotment of the land, the district shall be duly constituted within a purview of land policy. Out the said shall not in affect the forest of either today is included, so that is very clear, sir, already. Very clear order.
Well, that is why our issue was that they have issued a general notice asking all who have been occupying illegally.
Who have occupied the reserve forest or
Reserve forest or proposed reserve forest. Our
You are not
conclusion
on-
was
yeah.
also,
if you are not on reserve forest, why to worry about?
well, that is why, but they are not listening to, they are not doing according to the
That's why only
consultation of
learned
the
single judge
revenue
has
authorities.
already- That's why only the learned single judge has already taken note of the fact that you have already filed your representations and they shall duly consider the application within the purview of land policy of 2009.
Exactly, my lord. But notwithstanding that, since the court has said that your notice is not illegal, you can go ahead, that means, that is the message
Yes, the
given, my lord.
persons who have illegally occupied the land of the reserve forest or proposed reserve forest.
My lord, Had it been a reserve forest or proposed reserve forest, probably we could not have claimed anything. And earlier also, we not this time that we have come only by this time. Earlier also, this honorable court protected our interest.
Yes, 249. 249.
That is explained government to be. The violation you are basically for you.
Lordship will find, my lord.
Yeah.
Earlier, when we came before this honorable court, way back in 2004 itself, this honorable court declared single judge, that is the final order, attained finality, issued a direction that has not been complied with as yet.
Where is that?
Kindly see 249, page 249, last portion I am only referring to. Otherwise, it is a long order taking into account everything. Honorable Justice Amitabh Roy, that when he was here, Lordship got it 249, my lord. Last portion, last but one para. In view of the conclusion recorded with regard to the impugned notices, it is further provided that till such representation is disposed of, the petitioner's possession of the land presently occupied by them shall not be disturbed. In the event of the representations being rejected and the authorities are inclined to get the land vacated, they would follow the procedure prescribed by law for such purpose. It is further made clear that if no representation is filed, it would be open for the state respondents to take appropriate action against them as permissible under the law. We have filed a representation since then. 250, Lordship will find representations are there.
Yes.
My lord, that time also, this honorable court recorded.
We'll clarify this. We'll clarify this.
Kindly see, my lord.
We'll clarify this.
Yes, one of the authority first, let them determine.
We'll clarify this.
We'll be grateful, my lord,
This-
because there is a clarity. Otherwise,
We'll clarify this. This writ of this file.
at least Lordship will record that till today, department could not produce any document showing that this is a forest
We'll clarify.
object. Degree clear.
This writ appeal is prepared on behalf of the appellants being agreed with the order dated 2/2/2024. Passed by the learned single judge in. As we in writ petition number 8101/2017. Full stop. The appellants have approached the writ court being agreed with the notice dated 6/12/2017 issued by the Anchalik Forest Officer Reserve Forest Krishna District Gopalpura,
Gwalpara.
Gopalpara,
No, Gwalpara.
Gwalpara. Full stop. The notice. The notice dated 6/12/2017 is a general notice wherein it is mentioned that wherein it is mentioned that who have illegally occupied the land of reserve forest in bracket RF or proposed reserve forest in bracket PRF by constructing dwelling houses, comma, they are directed to release in bracket left the forest land within 31st of December 2017 to make the forest land completely free. Completely free with a caution that otherwise appropriate action will be taken against the illegal land occupier as per the departmental rule. Full stop. The appellants have challenged the validity of the said notice. On the ground that the same is illegal and without jurisdiction. The learned single judge has observed that it is settled that no rights can be created or approved in the reserve forest or proposed reserve forest. And therefore, there is no illegality in the notice dated 6/12/2017. At the same time, the learned single judge has also clarified that the forest authorities can only exercise such jurisdiction in the reserve forest or proposed reserve forest land and not in respect of other revenue lands. Stop. The appellants have filed this intra-court of appeal apprehending that since the learned single judge has held that there is no illegality in the notice dated 6/12/2017, the forest authorities may act against the appellants who are not occupying the reserve forest or proposed reserve forest lands and are in possession of the land, in possession of the revenue land. Full stop. Having heard the learned counsel appellant and after taking into consideration the impugned judgment as well as the material available on record, we make it clear that though the learned single judge has opined that there is no illegality in the notice dated 6/12/2017, but has also made it clear that the forest authorities can only exercise jurisdiction in the reserve forest and proposed reserve forest lands and not in respect of revenue lands. Taking into consideration the above, we may we clarify here that before taking action against the appellant or similarly situated persons pursuant to the notice dated 6/12/2017, the forest officials, the forest authorities are required to ascertain whether the lands occupied by the appellants or the similarly situated persons falls within the reserve forest or proposed reserve forest. After ascertaining the same, the forest officials, the forest authorities can take any action against only those persons who have illegally occupied the land of reserve forest and propose a reserve forest. With these observations, this writ appeal is disposed of.
Without following, completing that process, they may not go for issuing notices.
That they have clarified it in so many words, sir.
Well, my logic will appreciate my position.
We
By
have
being
clarified
there,
it.
By being there every
We
day,
have
they are knocking
clarified
at my
in
door.
we have
Every day
clar-
they are knocking at my door. When I say, show them, they say, well, where our notice is legal.
But Mr. Mahanta,
So, Malad, my response, only submission is, when this honorable court will direct, it should be such that they will clearly understand it. There will be no scope.
this is a direction
Direction.
and nothing
That,
else.
that is what I am praying for, Malad.
That is the direction.
I'm deeply obliged if it is there. Well, I only want that this should be very clear.
It's clear.
Obliged.
For final disposal, item 2.
Obliged.
Made physiology. My lord, as far as the termination of the contract is concerned, I'll avail my remedy, arbitration and all. But my lord, this termination of the contract is not a termination simplicity. It has got, my lord, other
But
consequences.
that is only for the 2 years period.
Yes,
That
that
was
is
only
too
for
much.
the 2 years.
No, my lord. Now here is a case. This termination will hold good or not, that will depend upon the, approach which I made. Now, until 2 years, if I am to stay, my lord, then my fundamental right under Article 19(1) to participate in a process will be lost. And because, my lord, and moreover, my lord will kindly come to the show cause notice.
Two point nine. What time is it?
Which are the other organizations. 179 is the MP job. Then it's, then it continues, no? Continues.
Live time. You see the. National last 2 years. Defines it. Participate in the content. Fine.
Huh.
NHIDC. NHIDC.
Yes. My lord, let me first come to this so-called notice, my lord. If your lordship will kindly come to page number 160.
160.
Yes. Now, if your lordship will kindly come to page number 163.
Yes.
On top clause 19. Whereas the authority under clause 29.1.f of general conditions of contract, if client is in its sole discretion and for any reason whatsoever decides to terminate this contract in reference of occurrence of any other event specified in under clause 29.2.9.1A2H. In the light of the above, the authority has issued this show cause notice without prejudice to the rights of NHIDCL available under the relevant provisions of the consultancy agreement as well as under applicable law on failure of the firm to remedy the failure, etc., etc. So essentially, my lord, the show cause notice was issued under clause 22.9.1F. Now, if your lordship would kindly come to that particular clause at page 127, my lord. It starts at page 126. Termination 2.9, 2.9.1. The client may by not less than 30 days written notice of termination to the consultant, except in the event listed in paragraph F below, for which there shall be a written notice of not less than 60 days. Such a notice to be given after occurrence of any of the events specified in paragraph A through H of this clause. So, my lord, what follows from 2.9.1 is, if it is a notice under F, subclause F, in which case it would be a 60 days notice as in the present case. And in any other case, it would be a 30 days notice for clauses covered by A to H other than F. Now, my lord will kindly come to page 127, clause F. If the client in its sole discretion for any reason whatsoever decides to terminate this contract. Now, how do I know, my lord, what is my wrong? No, I'm just, my lord, if when the show cause notice is under F, lordship note the subtle legal position, a show cause notice must contain a clause. It must be definite. It must indicate the wrong which I have committed so that it is intelligible to me, so that I can reply to the allegations. Now, what is this, my lord? By giving a 60 days notice under 2.9.1F, they have invoked clause F. So a clause F is vague, my lord. So this is my first ground of challenge.
Then you should have challenged that, sir.
No. Even then, my lord, no, my lord, supposing if I do that, court may say, why don't you reply, let us see. So, my lord, that way there is no bar to challenge this clause. Now the question is,
Once you entered into an agreement,
yes,
they open the eyes, and with this clause that is there,
yes.
which is as per you is vague, then you should have then challenged it.
No, my lord, it's not a question of not challenging. End of the day, my lord, there must be fairness. But if clause F is invoked in itself, then my lord, it entails what? I don't even know what is the allegation against me.
So the show cause, they issued to you,
Yes, I've read the so called notice at page 160.
160.
Yeah, there they have invoked 2.9.1.f.
Yes, then they must have shown the reasons for that.
No, my lord. They eventually they issued the notice under 2.9.1.f.
Yes.
After narrating the facts, if a lordship would kindly come to page 162. Whereas the consultancy firm has time and again failed to remedy failure in performance of the obligation as specified under various clauses of the contract. That is 2.9.1A, so and so, so and so, so and so. Now please come to 18. Whereas authority engineer has failed to perform and deliver the duties and responsibilities as the authorities engineer in the absence of key personnel in the project. Basically, they would say, my lord, there were absence of key personnel in the project. Now, my lord, as far as this key personnel is concerned, I'll come to that. That is a different chapter. Now, eventually, my lord, they have not issued the notice under A to H. They have issued the notice under F. That is why they have given us 60 days notice. In every other case, they are supposed to give, 30 days notice.
There are not only this.
Anyway, my lord, this is one of my ground. Now let us come to the main case.
There are the other grounds also.
No, my lord.
The contract between the NHS and the management was signed on 2.12. Whereas the office letter dated so and so issued to the notice suspension of service, consultancy agreement on account of failure to mobilize the key personnel on the site and firm incapacity to discharge committed service of the authority.
No, my lord,
The consultant letter dated so and so submitted the.
my lord, these are all recital, my lord. These are all recital of facts.
So these are the reasons. That's why only they formed the opinion in their discretion.
No, my lord.
This contract is liable to be terminated.
No, if your lordship would kindly come to page 126 once. Please come to 126.
Now.
The client kindly
Now,
see.
why we are. Since you have said that for the purpose of termination, you are supposed to,
Yes, will it go?
the party is agreeing to go for that arbitration and all. So without interfering with this, how can we interfere into this?
No, what I'm saying is, my lord.
Blacklisting or whatever.
No,
the,
no, what I'm,
debarring.
what I would try to submit for a lordship's kind consideration is, this termination entails not only termination of the work, it also entails blacklisting because I have given, my lord, 12 NITs of different organizations.
Debarring for a period of 2 years.
Yes.
For lifetime.
That,
No, in some of the organizations lifetime.
in some of the organizations, those organizations.
Yes, I have,
are different.
no, my lord, what I'm saying is, from page 174 onwards,
No,
I have given,
Our predicament is only there.
yes.
Is without looking into that termination order or validity of that termination. How can we
Yes.
suspend this debarment of future bids?
Precisely.
Clause,
Precisely.
clause, because it's a natural consequence.
No,
of
I'm
termination.
coming to that, my lord. Now, basically what the NHIDCL would like to say, that I was guilty of not providing key personnel. That is their basic grievance against me. Now, my lord, when it comes to this, my lord, I have no control over key personnel. If your lordship would kindly appreciate, I'm a consultant. It is NHIDCL who elect them, my lord, select them. I have absolutely no control over them. And my lord, they could have foreclosed my contract, in which event, my lord, I would not have incurred that disqualification of blacklisting. Now, whether this was required, that is an aspect lordship will have to look into. But at the end of the day, there has to be fairness in the action. They could have foreclosed my contract. They could have, recovered whatever fee is imposable that they could have done. By resorting to my lord termination, these consequences has
So
ensued.
ultimately, we have to look into the termination itself.
Exactly.
So for that, then you're not supposed to go to the
No, my lord.
arbitration.
No, but where do I go, my lord? No, this arbitration aspect cannot be decided by arbitral tribunal. The aspect of blacklisting, it cannot be gone into by tribunal.
So that is if the termination order goes, this provision also, this department is
Lord,
also different.
till then, my lord, then I will be without any job, work.
That is altogether different thing, but for these, to suspend this
Yes,
clause.
Yes.
We have to look into the termination itself.
yes.
Then the.
No, my lord,
So if you-
no, lordships can always say
Yeah,
they're pending the, decision by the Arbitral Tribunal.
that would be for us without interfering with the termination order, because it's a natural consequence of termination. Without looking into that, looking into the validity of the termination order, I don't think so. We can, we pass an order to.
No,
suspend this.
I know, my lord, this is
operation
not
of
a
this
case which, comes to before lordships off and on. Even I was also thinking, how to deal with this issue. My lord,
It's my happy if we invoke arbitration within 45 days,
Hmm.
then we will not comment to it. Let the.
Okay, then Milord will kindly come to page 130, Milord.
Yeah.
Yes.
This is really communicating so that we can.
Uh, Please come to clause 2.9.6.
Yes,
If either party disputes whether an event specified in clause A to through E of GC clause so and so or in so and so thereof has occurred, such a party may within 45 days after receipt of notice of termination from the other party refer the matter to arbitration pursuant to clause so and so hereof. And this contract shall not be terminated on account of such event except in accordance with terms of any resulting arbitral award. So my lord, let them, then my lords will kindly give me some protection in terms of this.
that is in A and E only, not in F. That is
A
in
to E, A through E.
Not in F.
Huh.
Here they have invoked the power of this F.
Now, my lord, kindly see, even under this contract also, what is the consequence? As a natural consequence of termination, due to consultant's failure, the consultant shall be deemed to have been deferred for a period of 2 years and shall not be eligible. Now, my lord, then my argument would be, if your lordship says it can be confined to A through E, in that case, my lordship will uphold my contention on, my lord, that the so-called notice is not clear. How do I meet that challenge? So, my lord, since I'll be approaching the arbitral tribunal, lordships can protect me because we have approached the.
That in between without interfering with the termination order, because it's a natural consequence. Now interfering with the termination order,
So, my lord,
what
the,
we feel,
no, the
we
contract
can't
is,
suspend this.
no, contract
operation
itself
of this
provides.
mechanism.
Contract itself provides that if I make an approach within 45 days, then this will not have the effect.
That is in relation to that only they have clarified A
Through E. Huh.
A through E, not
Huh.
F.
Or GC 2.9.2 also, my lord. 2.9.2 में क्या है? This is
129.
2.9.2 कहाँ है?
2.9.
2.9.2.
This is by the consultant, this is by me. This is by me.
Can also my consultant.
That is also this 2.6, 2.9.6.
Yes.
It's about within 45 days after receipt of the notice of termination.
Yes.
Not after termination. Notice of termination within 45 days of notice of termination. So any party within 45 days of notice of termination approaches, then the matter has to be referred to the arbitration.
No, my lord. Issue
Arbitrator.
no notice of termination doesn't mean that they will give me a notice to terminate. There's already a termination order itself is a notice of termination.
So that show cause notice, which
Yes.
they have given you.
Huh.
That was 60 days notice.
Huh.
That was 60 days
Yes,
notice.
yes.
And in case that was in F, that was in F.
Yes.
But in relation to this A to E, if there was a notice and within 45 days of that notice, if you approaches them and requested them that matter be referred to the arbiter, they are bound to do that.
No, my lord, what I, no, subject to correction, my lord.
Sir.
In fact, in this case, they have invoked actually 2.9.1A. If your lordship will kindly come to 2.9.1A, that is the clause they have invoked. Consultant fails to remedy a failure in performance of the obligation as specified in notice under so and so. Actually, they say, I could not mobilize the key personnel. That is their basic allegation. Though they have mentioned, my lord, F, but if we go by the substance of the allegation, then it is a notice under 2.9.1A. Sahi hai, wahi hai. It in substance is an allegation under A. Notice of termination बोलते कोई पहले notice करने एक ही है वो final है.
Actually, they should have given.
So therefore my humble submission is, my lord, let them clarify.
This notice, in fact, this notice, which you are referring to, it is not in 9.1.1A.
Yeah, no, so what I am saying is, my lord,
9.1A.
A, yes,
The consultant failed
Ah.
to remedy the failure in the performance of their obligation is specifically notice of suspension
9.1.
from 2.8 here
Ah.
within 30 days.
Ah.
So receipt of notice of suspension within such period,
Ah.
as the client may have subsequently approved in writing.
yes,
So this is the notice in that the 2.9.1A,
yes.
not 2.9.1.1.A.
No, 2.9.1A, that is the only one I am referring, my lord. My lord, if we go by the allegations set out in the show cause notice, in substance, it is a notice under clause A, sub-clause A. Though, my lord, in the para 19 of the operative part, they have said, they have invoked 2.9.1.F. In substance, it is, my lord. In form, it appears as if it is F, but in substance, it is A. And that is what failure to provide key personnel.
It is specific function of the application. I have already given. You have given three.
And
Right, they have not paid a single money. That also say they can deduct 20% of the salary.
And kindly see in this case, my lord, I have been given 3 penalties. Termination, blacklisting, that has been interfered.
That is blacklisting.
They're done for this.
Where is that?
Yes, that has been interfered by the learned single judge. That order, and my lord, the financial part, not a single pie has been paid. It's too harsh. Department is order is at 164. On 13/5/24.
164.
Yes. And the operative portion is at 168. Para 7. In the light of the above, feedback infra, so-and-so, so-and-so, so-and-so is hereby debarred from participating future projects of an nature either directly or indirectly from the issuance of this notice for a period of 2 years in accordance with so-and-so.
Yes.
Then we put to challenge, my lord, learned single judge has interfered with you.
No.
At page 169. And the operative portion is at, my lord, page number 178, para 17 and 18.
178.
Yes. Consequently, in view of the above reason, this court holds that clause cannot come in the way of issuing a prior notice to a person who is to be blacklisted. The person has to be informed as to the precise case set up against him, besides specifically making the person know that penalty of is being proposed to be taken against him. In view of the department, so and so is arbitrary and is set aside. ये हम लोग arbitration में जाना था तब बेनिफिट मिल जाता था immediately. Yeah, but arbitration जाने से तो automatic stay हो जाता था. Millard?
24-4.
Yes.
Termination order.
Yes, yes.
That is
1 second, Millard. At page 81,
81.
81. And operative portion is at page 86.
Just a minute.
Foreclosure वाला clause कहाँ है? Page है ना? very, very strong point. However, so the blacklisting was applied for weight because notice did not appear. That means in the same judgment. This point you should have highlighted. तो हम लोग ज़्यादा पसंद कभी बोले लंबा थी. It's a lordship with kind. Yes. मुझे natural consequence नहीं होगा. इसलिए then the benefit I must get. Judgment अभी that at the 18th penalty. That's extra. Milord will kindly come to.
So so essentially you prefer two writ.
Yes.
One is against the department notice. That is the first writ.
First
And
concept.
then against the termination order, second writ.
Yes. Correct. Milord, my submission is very clear, simple, Milord. If your lordship kindly comes to page 130,
Yes,
2.9.7. As a natural consequence of termination,
yeah,
so Milord, the learned single judges did not approve this.
that is some.
And that order has
We are-
attained
we are-
finality.
We are having some doubt about. Such department shall be natural consequences of the termination. No separate show cause
fact-
proceedings shall be initiated for placing such contract under debar.
Yes, and
This is what-
precisely that was the stand, and that has been rejected by the single judge. So therefore, my lord, if for this organization, this blacklisting will not operate. Now, if blacklisting operates in other department, it will operate harshly
Other
against me.
departments are- Other
Meaning, my lord, wherever,
the other
because
departments are not before us, sir. How can we?
no,
issue
I'm,
direction?
no, my lord, no, my lord, it's not possible for me either to, my lord, there are hundreds of departments. I cannot. Now, question is, my lord, the NHIDCL construed clause 2.9.7 as a natural consequence, they have the power to debar me.
Yeah.
They did, it has been interfered with by the honorable court. This honorable court says this clause will not come to your rescue. All that you'll have to do is, you'll have to give a show cause notice where you'll have to say why you should not be blacklisted. So as far as my lord blacklisting is concerned, there is an order in my favor. Qua NHIDCL. Now, my lord, F, yeah, this 9.7. So therefore, my lord, will it if your lordships would kindly come to page 177, my lord. The other judgment,
Sir, this.
para 14, page 177. With regard to clause 2.9.7 of the GCC, not requiring any prior notice to be issued before blacklisting a person, so long as the contract has been terminated, this court is of the view that said clause cannot be used to deprive petitioner from being given an opportunity of being heard because unequal bargaining powers between the parties has resulted in one-sided clause 297 being inserted into GCC. In the case of so-and-so Supreme Court had held, where an unfair and untenable or an irrational clause in a contract is also unjust, the same is amenable to judicial review. It further held that state itself or the state instrumentality cannot impose unconstitutional conditions in a statutory rules, regulation vis-a-vis its employees in order to terminate the services of its permanent employee in accordance with such terms and conditions. It further held that it is necessary to strike down an unfair and unreasonable contract or an unfair or unreasonable clause in a contract that has entered into by the parties who do not enjoy equal bargaining power as it is unreasonable and against public policy. Where inequality of bargaining power is the result of great disparity between economic strengths of the contracting parties, the aforesaid principle would automatically apply for the reason that freedom of contract must be founded on the basis of equality of bargaining power between such contracting parties, even though ad idem is assumed applicability of standard form of contract is the rule. Consent or consensus ad idem as regards weaker party may therefore be entirely absent. So, my lord, that automatic thing, my lord, or the natural consequence part has been, considered by this honorable court to be rational. So in that view of the matter, my lord, today, if I am not allowed to participate in other,
Very, very difficult. The learned single judge in the earlier writ petition. That view, we are also doubted about it. Yes.
but then my lord,
5/6/2024.
my lord, undoubtedly, my lord, it could be a matter where, but nobody is preferred any appeal against that.
But we have to deal with it, sir. Certainly, we have to deal with it and then we have to give some comments on it.
My lord, otherwise I was thinking, my lord, now if termination results further consequences,
Sir, that is the natural consequence and until and unless that provision itself is under challenge. Okay.
no, my lord, at least today there is a judicial finding. Today there is at least judicial finding, my lord, rightly or wrongly. Yeah, those judges complete.
that is that meaning of the learned single judge in 5/6/2024 is contrary to the finding in para number 10 of this July judgment. Altogether, the learned single judge here taken the view that you should have challenged that uh, it's better you go to the arbitration. It's better. Otherwise, our predicament is this,
Our
that without-
only, Milord will kindly appreciate one thing. Our only predicament is, Milord, this blacklisting cannot be subject matter of arbitration.
that the. so
That's why we learn-
Ultimately, it's a natural consequence of.
I'll
termination.
just,
Once the termination is interfered with by the arbitrator,
Milord, even
then
on,
certainly this.
even on
Oh.
that, if your lordship kindly permit me, I'll just place two clauses. Now, their grievance is that key personnel were not provided. Now, if your lordship should kindly come to page number 134. Let us go to the, just lordship will have just a glimpse of the merit of the case. No, my lord, I don't appoint these key personnel, my lord. Please come to page 134.
Then certainly, sir, we'll consider. it.
Sir, that is an aspect.
Then we'll have to go into this
Yes.
validity of the order itself.
Yes,
Yeah, then there is no question of referring you to the arbitrator.
yes.
That is there.
Even my lord, Supreme Court has said merely because there is an arbitration
So
clause.
that will.
That by itself,
will
yes,
consider- That
yes.
will consider whether the view of the learned single judge
Yes.
is supported by any law or not. That
Yes.
will consider. Then
Hearing
we have to go into the.
My lord, in that case, if your lordship would kindly give me some time, I can come prepared on merits of the case.
Fine.
Yes.
But-
He'd like to hear the whole merit. तब तो ठीक ही है. तो prepare करके आना पड़ेगा.
They want to file any.
My lord, the most difficult part is
If you go
they
to
have
the-
not filed any yes.
If you go to the application also, then section 9, you can move an application for interim protection there also. That,
Even before also we can do that. But my lord, the fact that lots, because of the judgment, other judgment of the single judge and the my lord predicament at which we are placed. My lord, it's not that my lord, because my lord, originally we were also thinking of going to arbitration. But in the peculiarity of the facts, perhaps lordships can entertain.
what was this strategy we fail to understand? That you have challenged this appellant has challenged the debarment notice first and thereafter the termination. That's very.
Anyway, my lord, if they want to file an affidavit, let them file, my lord, because they did not file the affidavit before the single judge.
They want to bypass the whole issue. First, they have filed a challenge the department order. Later on, they have.
But
filed the
it's strange
termination
that you have not also challenged that 5/6/2024 order of the learned single judge. It's very
Yeah,
strange.
In the process, Lordship, we are in the
In
process.
the process of.
Because it is a departmental, Lordship, we have to take
Would you
approval
like
of
to
the
file any-
ministry
Would
also.
you like to fight any counter to this?
Yes, Lordship.
When?
That is Lordship after vacation.
Lordship will fix a date, my lord.
Yeah.
Yes, after the vacation.
After vacation, my.
uh, 25th,
Yes.
No, 25th, I'll not be available.
25th October.
Huh.
25th, not having. Then Lordship, first week of November, any date.
Then 28th October.
Huh.
28th.
Yes.
ৰবা, মই নাথাকো, তুমি অ বুলি কৈছা। 28 or 29. Okay,
Okay, second of, then November,
2nd of November.
Perfect.
এই মই নাথাকো, মই যাব পারতাম।
not second of 4th of November. Second is the Saturday. 4th of November,
4th of November, yes.
Mr. Chaudhary, 4th November.
My friend has some difficulty. Can it be 5th, my lord?
5th, yeah, no problem. 5th of November. Run consent for the respondent.
Deeply obliged.
Time to file counter to the petition. Time to report is granted. Based on 5th of November.
Public.
Item 3 and 4.
By Pilo. This matter pertains to an RFA, regular fast appeal, and your lordship has already passed an order on 13/3/2024. The present regular fast appeal is already admitted. Hence, we deem it appropriate to raise this matter for hearing along with the lower court records in the month of September.
We want to ascertain why this regular first appeal come before the division bench, sir.
Why regular first appeal has come before the division? That is the problem. By mistake it has come. And your lordship has already passed an order on 13/3/2024.
Yeah, the appropriate list the matter hearing along with the lower court record in the month of September 2024. Yes.
So generally, fast appeal matters have been heard by the single bench.
Sir, in fact, there is a court order on 16/6/2023. Mr. Hajarika submits that since the original judgment was passed by the Deputy Commissioner of Haflong, the appeal should be listed before the division bench. Why Haflong?
My lord, regional court constituted
Yeah.
under the provision of the sixth schedule of the Constitution of India. That is not a regular court of. It is a constituted under the provision of the sixth schedule. District
the
Council
provision of-
court, this is regional court.
Okay.
Here in our court, my lord, all civil should decided by the judicial officer. But in Haflong, my lord, law is different. They have a special statute. They have a special statute which we call Administration of Justice Act and Rules. As per the Act provision of the Act, Section 3 of the said Act, the Deputy Commissioner has taken up civil and criminal both the matter in Haflong matter. That is called regional court. It is constituted under the provision of the sixth schedule of the Constitution of CRP. Then, my lord, there is a rule. When Deputy Commissioner or the additional Deputy Commissioner, power is same, when passed an order in a civil and criminal matter, maybe a murder case, maybe a rape case, or maybe a molestation, or in a land dispute matter. Then, if other party, defendant, they agree, they are to prefer appeal before the High Court. High Court rule says that when valuation of the suit is above 10 lakhs, that they are to approve before the division bench. Initially, they have challenged the judgment and order of the regional court. My Deputy Commissioner passed the order. They have filed a writ petition. An order which has been passed in the title suit. And thereby directed the Union of India to make payment of compensation to the 245 families of 14 villages. All they are tribal people. Their land has been enclosed, and that has been extensively damaged by the railway authority by saying that land belongs to railway. That is their claim. When matter has been come before the learned court below, my lord, that is before the Deputy Commissioner, they've been asked, if land belongs to you, then you are to produce land document before the court to prove your title, to prove your ownership. Now they have filed a writ petition before the High Court and challenging the judgment and order passed by the learned court below, that is by the regional court, and writ petition subsequently they have withdrawn. And writ court, learned single judge, directed them to prefer writable, prefer regular appeal in terms of the provision laid down into the special statement and High Court rulings. That is specifically mentioned. Now they have, after withdrawing of the writ petition, my lord, they have preferred it regular first appeal in terms of the provision of the CPC under Order 41, Rule 1. But in the special statute, it is specifically mentioned that the letter of CPC is not applicable. Only the spirit of the CPC is applicable. Rule specifically speaks that how the proceeding will be conducted, how evidence will be taken by the Deputy Commissioner while dealing with the cases. But my lord, in July 2017, the executive judiciary separated from executive. Haflong is the judicial building has been inaugurated and judiciary separated from executive.
Yeah.
Before 29 July of 2017, all cases, civil and criminal, deal with the deputy commissioner, additional deputy commissioner. If grievances is or erroneous crime, it is taken up by deputy commissioner. In case of simple simple offenses, my lord, that is taken by the executive magistrate. That is the procedure laid down in the special statute. So they are to prefer. He'll appeal before the Honorable Guwahati High Court, my lord. Instead of that, they have preferred regular fast appeal, my lord, under the provision of Order 41, Rule 1. That is why matter has been listed before the single judge, my lord. If they would file in terms of the provision laid down in the special statute, my lord, then matter will definitely come to the division bench. It is to be listed as ill appeal, my lord. That is the wrong they have committed. First, they have committed the wrong by filing writ petition, and that has been subsequently withdrawn after 4.5 years, my lord.
This
And
25
court has
seven-
given them liberty.
25/7/2017.
Yes, my lord.
Order, yes.
Yes, thereafter they have preferred it regular fast appeal. The regular fast appeal is not maintainable under the provision of the Order 41 Rule 1 CPC because letter of CPC is not applicable. Only the spirit of CPC is applicable because in the rule, my lord, Administrative Justice Act and Rule, it is specifically provided how the
We say that
deputy
this regular first appeal is not maintained.
not maintainable. Because they have to prefer he'll appeal before the division bench, my lord. Because it is the order passed by the deputy commissioner. Therefore, my lord,
Only
single
the
judge,
remedy available to them is writ appeal.
no, he'll appeal, my lord. He'll appeal. And another thing is that, my lord, the judgment, in the judgment, my lord, the learned court below has directed the Union of India, represented by the general manager, he is to make payment of the compensation to the beneficiaries, my lord, who lost their valuable.
Just like.
Kita boleh untuk apa? Boleh tak? Boleh.
Mr. Jatta, then even though if it is ill appeal, how it is to be heard by the division bench?
Hill appeal, all hill appeals taken by division bench, my
Sir,
lord.
where is that, is there?
Yes, our notice, my lord. Our, that notice, hearing list, my lord, there is a notice always notified, my lord.
Yeah.
All hill appeal.
Where is that, sir? Any notification from the?
Notification is available in the bench, my lord. That is not right now available with me.
Is there
The
any?
hill appeal, always a hill appeal
Any
taken.
date or something? Yes.
Here, my lord, in our hearing list, my lord, in here, our hearing, list, along with the notification also published by the court, my lord. Roster. Code number 10, my lord. Code number 10, the hill appeal taken up. My lord. Code number 10.
Code number 10.
10, yes. Code number 10. Code number 10, special division.
Uh, We'll keep this matter on any other day because we have to ascertain this hill appeal matter. Is to be listed and in that case, we have to either file an application for treating this as a hill appeal. instead of-
They approved before the Honorable Supreme Court against the condemnation of delay, Lord.
Yeah.
And the Supreme Court dismissed this petition, Lord. You have lordship in the next case at page 140. This order is there.
Yes,
Next page.
that is already there. Right?
Never directed by the Supreme Court to take up the
just-
matter by the single judge. Only Supreme Court says that this
Let me-
merit
let me-
will have to be reflected before the High Court. Whether it may be single bench or division bench, my lord,
Page 100
never directed.
Page
114. Against the condemnation of delay, they approved before the Supreme Court.
presenting special appeal plan to arranging a pending. That's why. Is kept open. That is kept open. They can very well raise this objection regarding maintainability of this RFA.
Mhm.
That is kept open. The Supreme Court has not commented on this.
No, they can
Whether the
approve.
only RFA is maintainable or his appeal is,
Yes, yes,
maintainable, they have not
No.
commented on. While granting them liberty to raise all the contentions on its before the High Court in the pending matter.
Hmm.
Pending matter, they have also not referred.
No,
in
the pending matter in the RFA number,
appeal.
pending matter in RFA number 137 of 2017.
What's wrong in that? Even though we are ready to hear, you have to.
Oh, yeah,
give the
no
nomenclature
problem,
of
no
this, RFA.
Yes.
They can very well move an application to treat this as a hill appeal
Yes,
instead of regular first appeal. That can be done by them. That can be done by.
Yes.
But let's ascertain. Let's ascertain from the registry that this hill appeal, because it says criminal appeal including hill appeal.
Yes.
Subsection 4 speaks about criminal appeal.
Yes.
There's no mention this the subsection 3 of this 1954 order, this clause 3, it speaks about civil suit, and clause 4 in criminal appeal shall lie before the High Court from the order of conviction of the sentence. Here they have said criminal appeal including Hill appeal. About
I could do it.
will ascertain from the office, and then because there may be some notification of this effect, will ascertain for the office. We'll keep it after Puja vacation. After Puja vacation.
Date. My lord. My lord,
Yeah.
second week of November, my lord, 7 or 8.
Okay, whatever you did.
Yes, 7 or 8, my.
And in the meantime, Mr.
They are to.
You
be
also
fast.
ascertain, and then if it is required, then
No problem. I don't have any problem.
yes.
So that will be beneficial for me. I have to argue the division bench.
7,
No, it's fine.
7
7.
November.
7, 11.
Yes.
Item 5 to 10.
Yes, Mr. Dev.
I'm for the appellants, my lords. Now, my lords, this particular appeal has been preferred by the state of Mizoram, my lord, against the order and judgment passed by the learned single judge in WPC number 30 of 2024, in writ petition number 30 of 2014, passed on 15th of November 2017. Now, before I enter into the merits of the matter, my lord,
Yes.
I would like to take your lordships, first of all, to a particular notification which was issued by this honorable court in the year lordship will 2015, notification number 43, dated 19th August 2015, wherein it was specifically notified that in continuation to this registry's earlier order, number 56, dated so and so, Honorable the Chief Justice acting has been pleased to order for filing matters challenging the virus of the acts and rules before the division bench number 1. Now, in this matter, my lord, the learned single judge, without considering this particular notification, had set aside the 2016 Mizoram Land Acquisition Act without considering this particular notification. That is number 1, my lord. Secondly, my lords, the act in question has not been challenged in the writ petition by the writ petitioners. If I can take your lordships to page 44. Page 44, my lords. Bare portion. The writ petition, my lords. Page 44. Last paragraph, my lord.
Yes.
It is therefore humbly prayed that your lordship please.
Just a minute.
I'm sorry.
Prayer part is not on page 44.
Page 44, it starts. starts from page 44. And then your lordship will come to
It's 54. 54 in this regulation.
54 is the, not 44.
my lord.
My lord, most probably the learned AG is reading from Writ Appeal 70, my lord. Item
Article
five-
70, my lord.
Item 5 is 71.
This is item number
5.
Sorry.
6. Yeah, 44.
Lordship,
Yes,
the act in question has not been petitioners, my lord.
rule number-
My first humble submission is that the notification of the Honorable Guwahati High Court dated
Ju- just a-
19th,
Just a minute, first of all, we have to look into the prayer of the religion.
Lordship. Your Lordship has got it.
Yes. Just a minute. Yes, we got it.
My lord, I am in 70.
Yes, we have one. Yes,
So the act was not challenged before the learned single judge.
yes.
And the learned single judge, my lord, had set aside this particular act without considering the prayer of the petitioner that this particular act has not been challenged. So there are two issues which needs consideration by your lordships, my lord. Number one is the notification which was issued by this honorable court on 19th of August 2015, which specifically mentions about the division bench 1 to take matters pertaining to virus of the acts being challenged. And the second issue is, my lord, what is your lordship's consideration that the act in question has not been challenged.
What is the finding of the learned single judge whereby it has set aside the act itself of 2016?
Lordship will come to page 25 onwards.
.227, lordship.
227, in fact. Paragraph 32. In view of the reasons. Paragraph 32. I'm sorry.
Sir, Mr. Dev,
Lordship,
if we go through the para number 32 of the
My lord.
para number 32 of the impugned order.
Lordship,
So it nowhere says that it is ultra virus or this act of 2016.
my lords, may I read out the paragraph?
Please read out.
In view of the reasons stated above, and by weighing down the Mizoram LA Act 2016 vis-a-vis the new LA Act 2013, this court finds that some provisions of the Mizoram LA Act 2016 regarding payment of compensation and solution, etc., are less beneficial, repugnant to the provisions of the new Act 2013. Further, the new Act 2013 has not received the assent of the President. Accordingly, in view of the reasons stated above, this court holds that the Mizoram LA Act 2016 is not applicable in the state of Mizoram. Consequently, the compensation to be paid to the petitioners will have to be made as per the new LA Act. So, my lord, not applicable.
Still have not been received. So then, single judge has simply said that it is not applicable in the state of Mizoram. It has not set aside.
Not applicable.
Not
The term not applicable, my lords.
Yes,
That means it cannot be used
not
in the state of Mizoram.
and he has given reason for that because that has
Yes,
not.
the reasons,
The-
merit I am coming, my lords.
As a-
My lord
any-
will give me the
as a-
opportunity to submit on the question of merits. That I will come. But first of all, at least your lordship will kindly consider that the issue pertaining to the notification and the issue pertaining to the act being not challenged, the learned single judge has made this observation that the act is not applicable for the state of Mizoram, which means
That doesn't mean. So this act of 2016 has now received the assent of the president
no, my lords.
till date.
I'm coming to that. I'm coming on merits.
So without even
But-
the assent of the president.
Yes, my lords.
Would be made applicable, sir.
Lordship, I'm coming. On the point of merits, I'm coming. Your lordship will give me an opportunity to submit before your lordship. Before
Yes.
that, I just wanted to point this out to your lordship. The two particular issues relating to the notification that the learned single judge cannot take up this matter. And in spite of that, the learned single judge heard the matter and disposed of the matter in spite of the notification being there. And secondly, the act being not challenged, he has specifically observed that this is not applicable for the state of Mizoram and 2013 Act is applicable for the state of Mizoram. Which means that the particular act has been set aside. Now coming to the merits, my lord.
That doesn't mean, sir.
Lordship,
That
Lordship,
doesn't mean that
when-
the particular
when-
act has
when-
been set aside. He has given a finding that
my
this
lords,
is not applicable and this is applicable only.
my lords, that means when the Honorable High Court is making an observation that this is not applicable in a
That is
particular
the fact
state,
of the case. That is in the
and the
fact.
other one is applicable. The fact remains that this cannot be made applicable and this cannot be used in the state of Mizoram for any land acquisition purpose. That is very specific. That is my humble submission, my lord. Now coming to the merits,
There's
my
not
lord.
any law on this point, sir.
Right at the moment, I don't have, my lords.
There
But-
is no, it can't
But,
be.
but this is my respectful submissions for your lordship to consider. Because once an act is not applicable, that this particular act A is not applicable.
Yeah.
And his lordship is making an observation that Act B is applicable.
Yeah.
So obviously, the state has to go on according to the Act B, as per Act B.
Yes.
The Act A cannot be made applicable under any circumstances, since there is a specific observation from the Honorable Court.
That is there.
So,
That-
so once it is not applicable, my lords, and if your lordship wants me to cite certain judgments on this, then your lordship can give me some time as far as this aspect is concerned. But regarding the matter pertaining to merits, your lordship will kindly give me the opportunity to submit on merits.
You argue on merits.
Yes, my lord. Lordship will kindly see Article 371G.
Just a minute. Yes.
My lords will kindly come to Article 371G of the Constitution. If I can take your lordship to 371G
So just a second.
A. No act of the parliament in respect of. This is a special provision with respect to the state of Mizoram, notwithstanding anything in this constitution. Notwithstanding anything in this constitution, no act of parliament in respect of, your lordship will kindly come to 4. Ownership and transfer of land. Ownership and transfer of land shall apply to the state of Mizoram unless the legislative assembly of the state of Mizoram by a resolution so decides. Now, my lord, the power of the parliament to enact any law is subject to the restriction under Article 371G, so far as the provisions are concerned. Article 371G says, notwithstanding anything in this constitution, no act of parliament in respect of ownership and transfer of land shall apply to the state of Mizoram unless the assembly of the state of Mizoram by a resolution so decides. Now, my lords, the Article 371G, being a non-obstantive provisions, overrides the general power of the parliament to enact any law that it is otherwise competent to do. That is my first submission, my lord.
So in this 371G,
Lordship,
this clause A, which there are 4.
Four.
So in which case you are
I am on 4. I am on 4. I am on 4.
ownership and transfer of land.
Ownership and transfer of land.
Recognition specific is what it is. Eight out has, there's one. This is not article on convenience list 3 entry 42 230 239.
Entry 42, I'm coming, my lord.
Just a minute, sir.
Page 239. Accusation of
The connection টা দেখুন unstable হচ্ছে। ঠিক আছে, ঠিক আছে।
land. It means land that is to say land right of it in or over land. Land tenures, including relation of land extension, connection, links, and concurrent listment, NP6, transfer of property other than agricultural land, registration of lease. So contradiction to all this, another separate agreement. Acquisition land. Registration of the new contract. So, 21G address to relate to clause 6, entry 6 of concurrent list. You to 18 to these, power. 18 minutes to put power. Please, Ownership and transfer of land. He dealt with it. He dealt with this in paragraph 24 onwards. 24. skip कर सकते हैं सर तो इंटरनेट पेज पे भी
Yes, Mr.
My lords.
Yes.
Thereafter, my lord, if I can take your lordships to Article 245 of the Constitution. Two 245(1).
Yes.
Extent of laws made by Parliament and by the legislatures of the state, subject to the provisions of this Constitution. And thereafter, my lord, it can be read along with 371G, which says that notwithstanding any provisions of the Constitution, which means that this particular provision overrides all other provisions. And 245(1) says, subject to the provisions of this Constitution. So therefore, under Article 245, my lords, the power of the Parliament to make laws for the whole or any part of the territory of India is subject to the provisions of this Constitution. And 371G says, notwithstanding anything in this Constitution, which is a non-obstante clause, which overrides all other provisions of this Constitution. So therefore, my lord, in my humble opinion and my respectful submissions, my lord, the power of the Parliament to enact any law for the entire territory of India is fettered insofar as the state of Mizoram is concerned. And so far it relates to transfer and ownership of land, which means acquisition. I will come to that. How it means acquisition, I will come to that, well.
Yes.
Lordship, the right of ownership. 371G4 says ownership and transfer of land. So the right of ownership has been interpreted by Supreme Court, my lords, in 1995, 5 SCC, page 238. If I can place this before your lordship.
Yes.
Page 241, paragraph 6. My lords have got B. Gangadhar versus B.G. Rajalingam.
Yes.
1995, 5 SCC 238, page 241, my lords, paragraph 6. In Black's Law Dictionary, 6th edition, the ownership has been defined as collection of rights, use and enjoy property, including right to transmit it to others. Therefore, ownership is de jure recognition of a claim to certain property. Possession is the objective realization of ownership. If my lords can further come down to paragraph D, the last portion. Ownership chiefly imports, if my lords have got it, the portion which I am indicating.
Possession in fact, right to enforcement.
No, thereafter. Thereafter, my lord.
Ownership.
After ownership chiefly imports. That is just D, line 5, 5th line. Ownership chiefly imports the right of exclusive possession and enjoyment of the thing owned. The owner in possession of the thing has the right to exclude all others from the possession and enjoyment of it. If he is wrongfully deprived of what he wants, the owner has a right to recover possession of it from the person who wrongfully gets into the possession of it. So ownership means, basically, my lord, what has been interpreted by the Honorable Supreme Court, that the entire bundle of rights is transmitted to the others. When the ownership goes, while my lord, a land acquisition is made, the entire bundle of rights of the owner is transferred from the owner to the state, and the owner loses the right of title and possession, and it is transferred to the state. So that is clearly interpreted by the Honorable Supreme Court in this particular judgment.
Yes.
Thereafter, my lords, I will come to the term acquisition.
Yes.
Land acquisition in respect of acquisition of property. So I'll come to the term of acquisition. The term acquisition has been interpreted, my lord, in Chiranjit Lal Chaudhary versus Union of India, 1950. As lordship will kindly come to.
Yes, next compilation.
Page 49. I'm sorry, paragraph 49. I'm extremely sorry, paragraph 49.
Please.
My lords have got it.
Yes, para 49.
Para 49. It cannot be disputed that acquisition means and implies the acquiring of the entire title of the expropriated owner, whatever the nature or extent of that title might be. The entire bundle of rights which were vested in the original holder would pass on acquisition to the acquirer, leaving nothing in the former. In taking possession, on the other hand, the title property admittedly remains in the original holder. Now we are not on possession, we are on acquisition. So Supreme Court, my lords, have defined acquisition in this particular paragraph, that the entire bundle of rights, title, ownership, everything is transferred on an acquisition proceeding from the owner to the acquirer. So therefore, my lord,
Yes.
So therefore, my lord, my respectful submission that acquisition entails deprivation of a person's ownership over a property and compulsory transfer of the same in favor of the state, which means a legislation dealing with acquisition of land in respect of an acquisition of land deals with ownership and transfer of land, which is clearly mentioned in Article 371G(4). So the ownership and transfer has been interpreted by the Honorable Supreme Court as submitted before your lordship, and it thus entails deprivation of a person's property and transfer of the same on a compulsory basis in favor of the state.
Yes.
So this is acquisition, my lord. Now your lordships will kindly come to the entries. The restriction, I'm sorry.
Yes.
Shall I proceed? Shall I proceed? The restriction under Article 371G, my lords, cannot be construed in the light of the entries in the 7th schedule. Lordship will kindly entry 42. Entry 42 of the 7th schedule.
Yes.
Acquisition and requisition of property,
Yes.
which relates to land acquisition, my lord. Now, my lords, under Article 246(2), both the Parliament, if your lordship kindly comes thereafter, Article 246(2).
The 46.
46(2), my lords.
Yes.
246.
246.
Lordship. Article 46.
So Dev, your voice is breaking.
My lord. Am I audible? Am I audible now?
Now you are audible.
Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state have the power to make laws with respect to any matters enumerated in list 3 in schedule 7. That is schedule 7, entry 42. So both Parliament as well as the state legislature has the power to enact a particular law. Now, entry 42 relates to Article 246. Now, my lord, the provisions of the Constitution, so far as a law being enacted by the parliament and by the state legislature, your lordship knows very well that it is sent to the President of India for the assent of the President of India if it is repugnant. Now, my lords, this particular act and some of its provisions are repugnant to the constitution. But why it was not being sent for the assent of the president, I'll come to that later on, my lords. But before that, my lords, I will like to place before your lordship that the parliament and the state legislature derive their powers to legislate from the articles of the constitution and not from the entries. Now, my lords, this was held in Vijay Kumar Sharma versus State of Karnataka, 1992 SCC, page 562. If my lords can kindly come to page 562. Brother, I would rather request your lordships to kindly come to page 621, paragraph 95. Paragraph 95. Shall I read it out?
Just a minute. Yes, para.
Para 95, my lords, which says that the said entries in the schedule, lordship,
Just a minute. Just a minute.
my lords, my lords.
$95.
My lords have got it.
Yes.
Thus, I hold that the parliament and the legislature of a state derive their power to legislate on a subjects in list 1 and list 2 of the 7th schedule to the constitution from article 246 1 and 3 respectively. Both derive their power from article 246 2 to legislate upon a matter in the concurrent subject to article 254 of the constitution. The respective lists, here I come, my lord. The respective lists merely demarcate the legislative field or legislative heads. The parliament and the legislation of the state have concurrent power to legislate upon a subject in the concurrent list 3 of 7th schedule to the constitution. Article 254(1) and proviso to Article 254(2) give paramountcy to the law made by the parliament, whether existing or made afresh or amended, modified, added, or repealing the law subsequent in point of time to the state law made under Article 254(2). Now, where I want to point out before your lordship the particular issue that both parliament and the state legislature derive their power from Article 246(2), that is, from the provisions of the constitution and not from the entries in the schedule. The entries are merely the fields of legislation. That is what has been interpreted by the Honorable Supreme Court.
Yes.
So, my lord, the fact that the entry deals with transfer of property and the acquisition of property, my lord, this squarely comes under the provisions of Article 371G4, which says land acquisition when it pertains to transfer and ownership of a property. And
Just
Single judge, the check recommendation. One interesting point is here, this bank application introduced by the parliament itself. On which mention, seems to be following. Including public spending, following past of the main. Government here means central government on the state. It's enlarging this one. For its own use and knowledge and control, including the public sector, public purposes, including the following purposes mainly. But here it says it extends to the whole of the. This thinking is the whole is already. So now that is being repeated. This is being problem. But then now, because otherwise, they might again. Was it is repeated by this and it might raise 1894. Eighteen ninety. Repeats 1890.
this 2013 Act and addition Act 2013.
Yes. Following. And other thing, section 24. Land acquisition procedure, payment absence services.
Not personally, in case of initiated in the city code, when an award under solution has been made 5 years or more prior, then automatically, yeah. So it's sort of a, if we become a one different thing, another, sort of a residual. You cannot say that this is in that or 40%. Like, okay, we can go to work. I mean, put that much of love. 1894, because that is there, sir. There is in that only if it is an existing law at that point of time, that will continue. In 371G, yes, that is. So, provided that nothing in this clause shall apply to any so and so immediately before the commencement of the Constitution 53 Amendment Act 1915. So that's but again, my opinion of this ownership and transfer that having been within that definition, because it says acquiring to form a public purpose. It's not a case where I'm selling my land to another person, but the transactions is not this. Only thing says there has to be some need to do. Some need has to be conclusion. Including some various situations from charging shipping in
Yes.
Now, my lords, the issue of inconsistency or the repugnancy will not arise due to Article 371G, as the field of entry 42 in list 3 is unoccupied. Because 371G gives a special and on the set provision, on the basis of the set provisions, my lord, the power of the parliament is curtailed at its very source, so far as making laws relating to transfer and ownership of property in Mizoram is concerned. It is not an unfettered power. It is the power of the parliament is fettered so far as making laws for the state of Mizoram as far as ownership and transfer is concerned, which relates to acquisition of property. So under such circumstances, my lord, my humble prayer, my most respectful submission, my lord, that the judgment passed by the learned single judge may be set aside and the appeals may be allowed. And one more point.
Yes.
Which was raised by the writ petitioner pertaining to repeal, that this particular, my lord, the lordship kindly comes to page 42. Page 42
Of
page 42.
yeah.
Page 42, paragraph 18.
Yes.
My lord will kindly come to the second paragraph. Section 114 of the new act, so and so, and then your lordships will kindly come to the second paragraph.
Yeah.
A conjoint reading of the provisions and the entire contents of the new LA Act 2013 goes on to show that the new LA Act 2013 is in effect an amending act of the LA Act 1894. Further, the LA Act 1894 has not been totally obliterated and wiped off. Rather, it has been continued to be made applicable, subject to the conditions laid down therein, upon the provisions of the LA Act 1894. have to be read along with those of the new LA Act 2013. Now, my lords, how can it be an amending act? Section 114 has clearly stated repeal and saving. Now, my lord, regarding repeal, I would, the Supreme Court has interpreted this in 2006, 3 SCC, my lord, page 63 and 64. If your lordship kindly comes,
2006.
63 SCC 354, paragraph 63 and 64.
Just a minute. Huh?
Should I read it out?
Yes.
In Halsbury's Law of England, 4th edition, the word repeal has been defined as under. To repeal an act is to cause it to cease to be a part of the corpus juris or body of law. To repeal an enactment contained in an act is to cause it to cease to be part of a law, a part of the act containing it. The general principle is that, except as to the transactions passed and closed, an act or enactment which is repealed is to be treated thereafter as if it had never existed. However, the operation of the principle is subject to any savings made expressly or by implication by the repealing enactment, and in most cases, it is subject also to the general statutory provisions as to the effects of repeal. Now, thereafter, paragraph 64. When an act is repealed, then it is treated as revoked or abrogated and removed from what is popularly known as statute book.
At 2, sir. At 2.
My lords,
But after this lunch, I have a brief bench and thereafter we'll continue.
my lords. I have in fact completed my submissions, my lord.
Just a minute, just a minute. Let's wait for, we have certain queries. So. you have
I will
to
be
ask-
there. I will be there, my lord.
2013 that so compared actually so scope.
Review petition.
My lord, what happened, my lord? Your lordship, can you bear with me for a minute? The service of the petitioner was terminated.
That we are aware
Yes,
of
my
that,
lord.
and we have simply said without adhering to the procedure laid down under the disciplinary rules,
Yes.
they can issue a show cause notice and decide the. that
Without
what's wrong in
adhering to the service rule.
Yes,
My lord, that was the direction. Now, what happened, my lord? In the meantime, there was a decision of the Honorable Supreme Court on my lord.
Exactly, that decision was prior to that.
Yes, my lord.
But in that case, the altogether different facts were there because they relied upon Board of Governors meeting dated June 2018. But the court, after going through that resolution, find that there is no such mention that his appointment was illegal. That is different on the facts of different case.
My lord, the facts.
Facts are quite different.
There, my
Mr.
lord,
Yashubat, sir.
there while my lord setting aside the order of termination, my lord, that liberty
Those
was
facts
not
are
granted.
altogether different from the fact of the present case.
In my humble submission, my lord, facts are identical because my
Not
lord,
identical, sir. We have gone through that. We have gone through that.
if your lordship has gone for and taken the view, my lord, I will not keep on insisting. My lord. My lord, the, sorry. My lord, the line of similarity that I was trying to harp upon is that, my lord, in that case also like the petitioner, my lord,
But in
they,
that case, the facts are quite different.
my lord, they,
Because,
both of them,
the
my lord,
termination order of the person relied upon this minutes of the meeting of 16 June 2018. It speaks about that. The court, after going through those minutes, has made a specific observation that the observation in the letter 19 May 22 is totally erroneous and contradicted by the minutes of the meeting dated 16 June 2018. That
My
was,
lord,
in that case, they said there was no basis for.
the similarity is that, my lord, in that, here also, my lord, the appellant, he
That's right.
completed.
After satisfactory completion of the probation, his services have also been confirmed. But here, the matter is regarding not termination. The question regarding appointment. Whether the appointment was in accordance with the law and not.
That is,
The only is the question.
that is the issue here also, my lord.
And we don't find that. Okay, the matter comes upon for consideration of the IA number 2628 of 2024 with the prayer to condone the delay of 20 days. How many days delay?
28 days, my lord.
28 days in preferring the review, connected review petition seeking review of the order dated 22/4/2024 passed by this court in writ appeal number 102 of 2024. Full stop. This court, by the order dated 26/2/2024, 22/4/2024, has dismissed the appeal filed on behalf of the
University.
university or
My-
on behalf of the university, non-applicant university, however, granted liberty to it to proceed against to proceed against the review petitioner by issuing, by providing opportunity of hearing to him. A observation is also made that while doing so, the university is not required to adhere to the provisions of the service rules
2019.
2019 of the 2019. Learned concept of the applicant has submitted that he has encountered submitted that he found that in a similar type of situation, the Honorable Supreme Court on 18th of April 2024 in civil appeal number the dash of 2024 in bracket arising out of SLP C number so and so, इसमें से you get it now. has ruled that the inquiry against the rule that the respondent institute can initiate the proceedings against the incumbent while following the procedure laid down under the rules. Then it council has submitted that since the case of the review petitioner is similar to the case wherein the Honorable Supreme Court has passed the order dated so and so, order dated 16th of April 2024, the liberty granted to the university of proceeding against the review petitioner without adhering to the rules of service rules of 2019 may kindly be deleted from the order dated 22/4/2024, passed in writ appeal number 102/2024. Full stop. Having heard the learned counsel for the heard the learned counsel for the applicant and after going through the material available on record, we are of the view that the facts involved in the Sandeep Kumar Supra, the facts of the Sandeep Kumar Supra are quite distinguishable from the facts of the case of the review petitioner. Full stop. In that case, in Sandeep Kumar case, the institute has terminated the services of the incumbent while relying on a meeting dated 16th of June 2018 of the Board of Governors. However, the Supreme Court has found that in the said meeting, no such observation regarding the qualification of the incumbent was there, and as such, the reliance placed by the institute on the said minutes of the meeting are erroneous, were erroneous. In the present case, no such situation is there. Hence, we don't find any case of review. In such circumstances, the IA number so and so, as well as the connected review petition number 7071/2024 in bracket filing number are disposed of, are dismissed. Sure.
Was there in the fifty-one judgment?
Short back about type.
Yes. Yes, Mr. Dev.
So my lords, so far as the repugnancy part is concerned, that this needs to be cured under Article 254 by the assent of the President of India, my lord. Now, on account of 371G, which I have submitted before your lordships, this particular field of entry 42 of list 30 of list 3 is unoccupied. Because 371G, this special provision, it is very clear, my lord, that notwithstanding anything in this constitution, and 245 says, subject to the provision of this constitution. So, my lords, the power of the parliament, so far as enacting any law with regard to transfer and ownership of property is concerned, which no doubt pertains to land acquisition, this power of the parliament is fettered. There is a restriction on the power of parliament at its very source, my lord. So, my lords, my humble submission that the appeals may be allowed and the judgment and order dated 15th of November 2017 may be set aside by this honorable court.
Yes. That Charanjit Lal Chaudhary, you have referred to that, which para you have referred to?
My lord,
49.
49. $49, my lords.
Yes. Yes. That's all, Mr.
That's all, man. That's all.
Yes.
Wait, please, Your Lordship. Lordship, before we go into the merits of the matter, just a brief indication of the facts. My lord, if my lord may come to, if Lordship is taking up writ appeal 70, then Lordship may come to page 110.
Seven zero.
70.
Yes, 70, yeah.
70. It starts at page 107, my lord.
Yes,
It's a judgment order 26/4/2012.
yes.
My lord, our lands have been under forceful occupation of the Assam Rifles for a long period of time. That is why we had come before the learned single judge at that point of time, saying that if they want the land on a permanent basis to acquire them or to vacate the land. On this, my lord, the order was passed, my lord, on 26 April 2012. At page 110 is the operative portion.
Page,
110, my lord.
yes.
Para 9.
Yes.
In view of the stand taken by the contesting respondents in the affidavit and submissions made by learned counsels, the controversy raised in the writ petition has narrowed down to a very short compass. As the respondents have admitted that land measuring 57.73 acres at Lunglong, Lunglei district is required for public purpose and should be acquired, for which they have taken up the matter with the district collector, this court is of the view that the writ petition can be disposed of by issuing necessary directions to the respondents, more particularly respondent number 6, to initiate land acquisition proceeding in respect of the aforesaid land under Land Acquisition Act 1894 by issuing necessary notification under section 4(1) of the said act within the period of 3 months from today, ordered accordingly. Since the land in question is admittedly under occupation of the security forces for about 46 years, the respondents shall proceed with the acquisition proceedings with utmost expedition by scrupulously following the provisions of the Land Acquisition. But it was at this juncture, my lord, that the notification came to be issued, the preliminary notification under 1894 Act, which is on the next page, my lord. This was issued, my lord, on 5th of July 2012, and thereafter a declaration was made. My lord, in the meantime, the 2013 Act had come into force, and that kept things in a state of limbo, my lord. Nothing proceeded with the acquisition proceedings. It was then that we had approached the learned single judge, my lord, saying that the acquisition proceedings be brought to its logical conclusion by application of the 2013 Act because of the section 24 of the 2013 Act. Section 24 says that if the award is not passed, then the proceedings will be, yes, my lord. The computation has to be done under the 2013 Act, but the land acquisition law of 1894 Act will apply. But the compensation part has to be under. It was at that juncture that we had come. My lord, during the pendency of the writ petition before the learned single judge, first of all, the state of Mizoram came up with an ordinance, which ultimately lapsed. The hearing was taken on different status, my lord. After the ordinance lapsed, they come up with the bill and the act was passed, the Mizoram Land Acquisition Act of 2016. My lord, my prayer before the learned single judge, my lord, was to apply the 2013 Act. I did not challenge the 2016 Act. Reason being simple, my lord, when I had approached the learned single judge, the 2016 Act was not in existence at all. It was only at the instance of the respondents, my lord, that they tried to bring in 2016 Act and say that the 2013 Act will not be applicable. That was the context behind which the judgment of the learned single judge came to be passed. My lord, the other aspects of it. My lord, the respondents have, the appellants here, my lord, have sought to project it as a simple case of transfer and ownership of land to bring it within the ambit of Section 3 or Article 371G of the Constitution. My lord takes up the Transfer of Property Act. My lord, Section 5. Transfer of property defined. Yes. In the following sections, transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself and or to any other, any one or more other living persons, and to transfer property is to perform such an act. In the section living persons, so and so. But note here, transfer is a voluntary act which is sought to be done under the Transfer of Property Act. But in the context of acquisition, my lord, acquisition is not voluntary. In acquisition, my lord, the property of a person, the person is deprived from the property by the application of the principle of eminent domain. I have certain judgments, my lord, on that. My lord, so it is not a simple case of transfer or ownership of land, which is under the ambit of acquisition.
What do you want to convey?
My lord, the projection made on behalf of the state that acquisition would fall within the ambit of transfer
of land.
That is incorrect, in my humble submission. It is not transfer.
That constitution and judgment of 1950.
My lord, that is in respect of shares of Sholapur Spinning and Weaving Company, my lord. That is not in respect of land and others, my lord.
Acquisition, the words used by the this Honorable Supreme Court.
My lord.
That acquisition means complete transfer.
My lord, my lord, my lord.
Para 49.
My lord, my lord. Of course, I have the SCR, my lord, but anyways, my lord.
It cannot be disputed that acquisition means and implies the acquiring of the entire title of the expropriated owner. Whatever the nature or extent to the title might be, the entire bundle of rights which were vested in the original holder would pass on acquisition to the acquirer, leaving nothing with in the former.
My lord, in respect of property, the property in Chiranjit Lal Chaudhary, my lord, was shares.
It is a
The-
general observation. It
My lord, it's a
applies
general
even on the
Yes.
property, shares or land or whatever it.
Well, I have a reply to that in the compilation which I have given.
Your compilation.
If my lord takes up flag C, my lord. Tukaram Kana Joshi, my lord, 2013, 1 SCC 35,
C.
my lord. 2013, 1 SCC 353.
B. It's not like C, it's B. Like D.
Sorry, my lord, flag D, flag D. Sorry.
Yes.
If my lord comes to para 8,
Para
para 8 of Tukaram Kana Joshi,
8.
8, my lord.
Yes.
No. The appellants were deprived of their immovable property in 1964 when Article 31 of the Constitution was still intact, and the right to property was a part of fundamental rights under Article 19 of the Constitution. It is pertinent to note here that even after right to property ceased to be a fundamental right, taking possession of or acquiring property of a citizen can certainly tantamount to deprivation, and such deprivation can take place only in accordance with the law, as the said word has been specifically used in Article 300A of the Constitution. Such deprivation can only be by resorting to a procedure prescribed by a statute. The same cannot be done by way of so-and-so, my lord. Thereafter, my lord, para 9. The right to property is now considered to be not only a constitutional or a statutory right, but also a human right. Though it is not a basic feature of the Constitution or fundamental right, human rights are considered to be in the realm of individual rights, such as right to health, right to livelihood, right to shelter, employment, etc. Now, however, human rights are again, so my lord, there is a discussion thereon. Then, my lord, para 10. In the case at hand, there has been no acquisition. The question that emerges for consideration is whether in a democratic body politic, which is supposed to be governed by the rule of law, the state should be allowed to deprive a citizen of his property without adhering to the law. The matter would have been different had the state pleaded it has right, title, and interest over the state land. If it concedes to the right, title, and interest of the appellants over such land and pleads the doctrine of delay and laches, so and so, my lord, then my lord may come to para 11. This is on eminent domain, my lord. There are authorities which state that delay in latches extinguish. My lord may directly come to my lord, the editor's D, my lord, just beside para 11. On the margin, my lord.
Para 11.
Para 11, the editor's marking D, my lord, on the left-hand margin.
D, yeah.
D, my lord. The three words from the end, my lord, the state must.
Yes.
The state must either comply with the procedure laid down for acquisition or requisition, or any other permissible statutory mode. There is a distinction, a true and concrete distinction between the principle of eminent domain and police power of a state. Under certain circumstances, the police power of the state may be used temporarily to take possession of property, but the present case clearly shows that neither of the said powers have been exercised. A question then arises with respect to the authority or power under which the state entered upon the land. It is evident that the act of the state amounts to encroachment in exercise of absolute power, which in common parlance is also called abuse of power or use of muscle power. To further clarify this position, it must be noted that the authorities have treated the landowner as a subject of medieval India and not as a citizen of India. The state, especially a welfare state which is governed by the rule of law, cannot arrogate itself to a status beyond one that is provided by the Constitution. Our Constitution, so my lord, my lord, what I am on.
This is relevant.
My lord, what I am on.
Thing is, whether the compensation is to be paid, there is no denial to that. That your property is acquired and compensation is to be paid.
My lord.
Whether it's under the Act of 2013 or 16, this is what the issue is.
My lord, here the first part.
Now, the learned AG is stated that since as per the section 37, the article 37G clause 4, the state is empowered to enact its own laws in relation to the ownership and transfer of the land.
My lord.
And they've enacted it.
My lord.
And therefore, this Act of 2013 has no application and only the Act of 2016 would apply.
My lord.
This is what the plain and simple submission.
My lord. But here the learned single judge has also dealt with this issue. If my lord comes to the learned single judge's para 20. Para 24 onwards, my lord, page 220.
Para 24.
Yes, my lord.
Yes.
With regard to the contention made by the Council for the State Government that the new LA Act 2013 cannot be made applicable to the state of Mizoram as the state legislature has not adopted the act in view of Article 371G of the Constitution, this court on reading entry 42 of concurrent list vis-a-vis entry 6 of the concurrent list and entry 18 of the state list of the 7th schedule finds that there is no bar imposed on the application of the new LA Act 2013 by Article 371G of the Constitution. Article 371G of the Constitution is reproduced below, so and so on. Thereafter, my lord, this court finds that the purpose or object of Article 371G is not related with acquisition. Clause 4 of Article 371G has been inserted mainly to protect the rights of the natives of the state of Mizoram. The rules laid down in Hayden's case has to be read into Article 371G, and the question of mischief does not arise in the case of acquisition of land. The lands to be acquired are for the central government, and as such, the doctrine of eminent domain comes into play in the present case. No doubt, acquisition of land implies the acquiring of title to land. However, ownership and transfer of land, which is protected by Article 371G, is not relatable to acquisition of land for a public purpose. Article 371G is relatable to transfer of land, not acquisition. We have to understand that transfer of land in normal course involves payment of consideration, while in acquisition proceedings, there is payment of compensation. Article 371G of the Constitution does not give any protection to the earlier customary rights and interests of the Mizo chiefs over ownership of land in the state of Mizoram after promulgation of the Assam Lushai Hills Act District Acquisition of Chiefs Right Act 1954. Thus, land in the state of Mizoram, erstwhile Mizo District Council of Assam, vested with the state after promulgation of the said act. The land laws made thereafter by the Mizo District Council was to safeguard the land for the natives of the state. Also, it may be reiterated that Section 1(2) of the new LA Act 2013 extends the said act to the state of Mizoram. Entry 18 and entry 2 were of list 2 and entry 6 of list 3 were reproduced thereafter, my lord. And thereafter, decision, my lord, 2002-8 SCC was relied on. Then para 28, my lord. A reading of entry 18 of list 2 does not specifically mention the word acquisition, while entry 42 of list 3 specifically mentions acquisition. A perusal of entry 18 of list 2 also does not give any indication that acquisition of land is involved in the state list. Thereafter, Kantimati plantations and all, my lord, repugnancy thereafter comes in. My lord, what the learned single judge was on as well, which is also my submission, my lord, is that since there are two separate entries, one in the concurrent list pertaining to acquisition, the other pertaining to land in the state list. My lord, acquisition is totally different from transfer insofar as my lord, legislation is concerned.
That you have to satisfy.
My lord.
That you have to satisfy.
My lord.
That acquisition is completely different from the transfer.
My lord. If my lord.
Able to make a distinction.
My lord.
What the learned single they also made, but you have to strengthen that.
My lord, my lord. My lord. Here, my lord, if my lord takes up entry 18 of list 2.
Yes.
My. It is, my lord, land, that is to say, rights in or over land, land tenures, including landlord and tenant, collection of rents, transfer and alienation of agricultural land, land improvement and agricultural loan, colonization. This is what the state is empowered to do under, my lord, entry 18. My lord,
Transfer and alienation.
My-
Transfer,
my lord,
this acquisition is different from transfer. You have to satisfy that what we are insisting, sir.
my lord, my lord here, then, my lord, list 3, my lord,
Yeah,
entry 42.
entry 42, it speaks about acquisition and requisition of property.
My lord. So these are two separate heads under which the legislature can legislate, my lord. Had it not been two separate heads, my lord, had it not been two separate subjects, my lord, it would not have been separately entered in the lists, my lord. Had acquisition been part of, my lord, transfer of land, it would have come under, my lord, entry 18 of list 2, my lord.
Me law, Mr. Pope.
My lord, I could not find anything specifically on that, my lord. But what I was on, my lord, is that acquisition would mean deprivation of property, not transfer. Transfer would contain a voluntary act of transfer. Because acquisition, my lord, is under the power of the state by exercising eminent domain.
This acquisition is different from transfer. Acquisition means
Acquisition means deprivation of property.
separation of property by force of law.
By operation of law, my lord.
Operation of. Whereas transfer is an voluntary act.
My
Yes.
My lord, this is what was discussed in Tukaram, as well as, my lord, 95 supplementary 1 SCC 596.
Tukaram, there is the Tukaram, there is the specific,
There
this
is-
type of observation.
My lord, there is no such specific observation to that
That
effect.
is, that,
My lord,
to be specific, where is that, sir?
that specific observation I could not find, my lord, but this was, this is what,
1995, which.
my lord, my flag, my lord, is flag E, my lord. 95 supplementary 1 SCC 596, my lord.
Yeah,
It discusses Chiranjit Lal Chaudhary as well, my lord.
yeah.
My lord. My lord, from para 34 onwards, my lord. Page 622, my lord, of SCC page 622.
Yes.
My lord, para 34 is eminent domain. Para 35 discusses Chiranjit Lal Chaudhary. This court in Chiranjit Lal Chaudhary versus Union of India held that eminent domain is the right inherent in every sovereign to take and appropriate private property belonging to individual citizens for public use. The limitation imposed upon acquisition or taking possession of private property, which is implied in clause 2 of Article 31, is that such taking must be for public purpose. The other condition is that no property can be taken unless the law which authorizes such appropriation contains a provision for payment of compensation in the manner laid down in the clause. In state of Bihar versus Kameshwar Singh, the eminent domain was held to be the right inherent in every sovereign to take and appropriate private property belonging to individual citizens for public use without the owner's consent. The limitation imposed upon acquisition or taking of possession of private property, which is implied in clause 2 of Article 31, is that such taking must be for public purpose. The other condition is that no property can be taken unless the law which authorizes such appropriation contains a provision for payment of compensation in the manner laid down in the clause. Mahajan J, as he was then, quoting from Thayer's cases on constitutional law, stated, shorn of all incidents, simple definition of the power to acquire compulsorily or the term eminent domain is the power of the sovereign to take property for public use without the owner's consent. The meaning of the power in its irreducible terms is A, power to take, B, without the owner's consent, C, for public use. The concept of the public use has been inextricably related to an appropriate exercise of power and is considered essential in the statement of its meaning. Payment of compensation, though is not an essential ingredient in the connotation of the term, is an essential element in the valid exercise of such power. And my lord may come to para 41. When we consider the right to life to be, sorry, just my.
Forty-one.
41.
Yes.
When we consider right to life to be meaningful, deprivation of property needs to be considered from the broad constitutional spectrum. Property in a comprehensive term is an essential guarantee to lead full life with human dignity. For in order that a man to be able to develop himself in human fashion, in full blossom, he needs a certain freedom and a certain security. The economic and social justice, equality of status and dignity of person are assured to him only through property. And so thereafter, the last 3 lines of this paragraph, the term property in Article 300A receives its true color and reflection from the context in which the state's power of eminent domain or police power is invoked and effectuated. Property in a legal sense means an aggregate of rights which are guaranteed and protected by law. It extends to every species the valuable rights and interests, more particularly ownership and exclusive right to a thing, the right to dispose of the thing in every legal way, to possess it, to use it, and to exclude everyone else from interfering with it. The dominion or the indefinite right of use or disposition which one may lawfully exercise over a particular things or subjects is called property. The exclusive right of possessing, enjoying, and disposing of a thing is property in legal parameters. Therefore, the word property connotes everything which is a subject of ownership, corporeal or incorporeal, tangible or intangible, visible or invisible, real or personal, everything that has an exchangeable value or which goes up or makes wealth or estate or status. Property, therefore, within the constitutional protection denotes group of things inhering citizens' relation to physical things as right to possess, use, and dispose of it in accordance with law. My lord, but transfer, my lord, as the transfer of, insofar as land is concerned, as the Transfer of Property Act says, my lord, it is the voluntary act. It is section 5 says means an act by which a living person conveys. Here, my lord, the land which is sought to be acquired is not voluntarily conveyed. It is acquired by depriving him from his property. He is not paid a money value for in exchange of the land. He is compensated, my lord. So therefore, my lord, it cannot be said that acquisition is equivalent to transfer. Those two operate in different fields, my lord. Yes, one of the other part, other leg of my submission, my lord, is the application of the 2013 Act. The 2013 Act, my lord, it applies to the whole of India as per section, my lord, 1.3.1.2, my lord. The whole of India except Jammu and Kashmir. Whole of India includes,
Except me, that is also deleted.
my lord, my lord, my lord.
That is like.
No, my lord, that has gone, my lord. But it extends to the whole of India. So therefore, my lord, it applies to the state of Mizoram as well as on the date of publication of the preliminary notification. By virtue of operation of section 24 of the 2013 Act. And another aspect, my lord, on application of the Act. Yes, 107 of the 2013 Act. It empowers the state, this is applicable to the whole of India, and 107 empowers state to enact laws on matters of land acquisition as well. But my lord, those those acts, my lord, have to be specifically more beneficial. If I may read 107, my lord.
Then I would have 2013.
13.
Yes, 107 is there.
My nothing in this, my lord, facts. Nothing in this act shall prevent any state from enacting any law to enhance or add to the entitlements enumerated under this act, which confers higher compensation than payable under this act, or to make provision for rehabilitation and resettlement, which is more beneficial than provided under the act. Oh, my lord, the differences between these two acts, the 2016 Act. Yeah. No, they were clearly less beneficial, my lord.
How?
My lord, first of all, my lord, section 26(2) of the new LA Act, it provided for multiplication factor in the first one. That is not there in the 2016 Act. My lord, I have put it in my affidavit before the learned single judge also, but just to,
Difference or many other?
many more, my lord, many more. Second, my lord, there is no provision for any cess on the compensation payable under the 2013 Act. Whereas section 28 of the Mizoram Act, it provides for cess. Then, my lord, section 30 of the 2013 Act, section 30, it provides for 100% solecia. But in the Mizoram Act, the solecia may extend, my lord, to 100%. It is completely discretionary.
Maybe less than.
Maybe even zero also. There may not be any solecia as well, my lord. In addition to
Yes. Yes, fine.
Yes, my lord. It's another aspect of the matter, my lord. In 2000, from 1st of January 2014, the Land Acquisition Act of 1894 was no longer in force, my lord. My lord, Section 11A of the 1894 Act provides that if the award is not passed within 2 years from the date of declaration, the proceedings shall lapse. My lord, that was the reason why we went before the learned single judge. In 2014, my lord, the Mizoram Land Acquisition Act was not in force, my lord. It was not even enacted, my lord. It received the assent of the governor on 22nd of April 2016. Mizoram Land Acquisition Act, the
2016.
2016. So, but it is not a case like normal acquisition when the property award is passed and thereafter the property is acquired. Here, my lord, our property, our land was already in occupation. It was only pursuant to directions from this honorable court that they were directed to be acquired. So therefore, my lord, as on 1st of January 2014, the only land acquisition law applicable in India, my lord, was the 2013 Act. So the compensation has to be, my lord, calculated and computed under the 2013.
This direction regarding acquisition is by this court when?
My lord, it was, my lord, 26th of April 2012. My and it was directed to be done with utmost expedition. Yes.
So the award, still the award has not been made.
Not been made. My lord, there is another issue, my lord. I have filed one additional affidavit, my lord. They have in fact applied the 2013 Act, my lord, for acquisition of areas in Aizol. My lord, in my additional affidavit filed in,
After this.
after this, my lord,
After this.
after this,
What is that?
my lord. My affidavit filed in the writ petitions, my lord, additional affidavits, my lord, filed on 4/11/2019.
4/11/2000.
19, my lord. In the writ appeal.
The page that,
The,
this paper book, page number.
my lord, will be. My lord, is 249 should be 249.
This dated
My lord, preliminary notification 11/6/2000.
4th November 2019 affidavit dated.
Yes, my lord. Yes, my lord.
Yes.
Annexure B to that affidavit. Should be around 249. 48 to 49. Annexure B, my lord.
This fact was not brought before the learned single judge.
No, this was after the judgment.
Annexure
Annexure B, my lord.
19, yeah.
It's 19. 11 June 2018, my lord. Whereas it appears to the government of Mizoram that land occupied by security forces at helipad area Thuampui, Aizol, hereinafter referred to as the said land, has to be acquired by the security forces under Ministry of Defense, Government of India, in compliance with the Honorable High Court's order dated 21/5/2018 in contempt case so and so, my lord. And whereas proposed area is acquired to facilitate appropriate final decision on the proposal under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, subject to any legal provision that may arise later regarding applicability of Act and also applicability of the MLARR Act 2016, that the initiation of land acquisition proceedings under the said Act is only for compliance of the Honorable Guwahati High Court's order in contempt case so and so. This was
Is in compliance with the honorable court's order, madam.
my lord, this
The
was.
challenge,
And subject to the outcome of this writ appeal.
where is that writ appeal? What happened to that writ appeal?
This is the writ appeal, my lord.
No, this, the 19. This page number
No,
19.
this was actually as per the direction.
So, if
As-
the gives you direction, you will not, they supply this.
In compliance with the direction of the court, my lord.
My lord,
What happened to thereafter, the court's order has attained finality or what?
my lord, there was no direction to acquire under the 2013 Act. Under the direction was under the appropriate land acquisition law.
That is, you have.
Subject to the outcome.
I can furnish, my lord. I can furnish. I can,
It is there.
not readily, my lord.
So then you should.
It's not ready with me
How
also.
you are making
By
this-
tomorrow I can furnish,
Here already.
my lord. Or. Or after, if my lord gives me just some time, I can take a printout, my lord.
And what about this, this annexure C?
My lord, It is a declaration pursuant to this particular preliminary notification.
In relation to that.
The Pampui helipad area, my lord, in Aizol. On the basis of this, the draft award was made, my lord, and award attained also final. Yes, my lord. Yes, my lord. Aizol. I'll furnish a copy to the court master just after some time. Take a printout.
So before, is this, this condition number 16 of 2013. No, no, idea of it.
No, madam, no, madam. We were directed to be paid as per the admitted amount, though no award was passed. Because before the learned single judge, since we have not been paid any compensation, before the learned single judge, we moved some internal interlocutory applications, my lord, to be paid the admitted amount that was allowed, which the learned division bench also reiterated later when the writ petition was placed.
So as per 2016 Act, they have already
Yes, madam.
given.
Only the market value.
Hmm?
Only the market value, no interest, no solution.
No solution.
Yes, the case which is referred to in the preliminary notification, my lord, that was pending not pending, my lord, the litigation went on from 2002. So that is why there was an order in the contempt, my lord, to inquire it. In the preliminary notification for the helipad which lodged as well.
My lord, in fact, when this appeal was admitted, my lords, at that time, there was a direction that the state of Mizoram should pay as per 2016 Act,
Fine.
subject to the outcome of the appeal.
Yes.
That
Anyway,
direction was there.
anyway, subject to the outcome of the appeal, if we hold that, yes, 2013 Act is applicable and not 2016, then you have to pay some more. Or
My lords,
we come to the conclusion is that 2016 Act is only applicable, then that matter ends there.
my lords, my lords.
Or you just give us the copy.
Not this one, madam, because there were many litigations pending in respect of the Aizawl helipad, madam.
Content case, content case.
Mr. Nair, please share one copy with my junior.
Of course, of course. Let him find out first.
Petition number 16/2013. Red petition number 16/2013. The child, title is
Zokai Liana.
Shri Zokaliana and 5 others.
Yes, because of those 2002 writ petitions.
One is of the 2012 and another is 2016.
My lord, my lord. 2016, I had appeared, my lord.
My friend is come again for this. What are they doing? What are they doing?
Yes, my lord. It's a case. My lord.
Yes, supply us the copy by tomorrow.
By tomorrow.
Yes, anything else?
My lord.
Yes.
No.
My
So
lord,
far, my lords. So far, my lords, the question of acquisition is concerned, my lord. I have made my submissions and I strongly rely on Article 371G, which has imposed a restriction on the power of the Parliament to make any laws relating to transfer and ownership. And acquisition has been clearly as transfer and ownership of land by the Honorable Supreme Court.
Fine.
That's all, madam.
Yes.
Malo, please.
You are
Please,
for,
please, item number 10, let us start with item number 10.
no, you are also for one of the landholder.
Yes, we are appealing, we are challenging the act 2016.
2016 act you are challenging.
We have challenged. And the single bench passed an order that this is res judicata. WA 2 of 2024. After the index, my lord, after the index, there is a judgment, impugn judgment, which I'm challenging. That Roman number 2.
You have challenged the validity of 2016 act.
Yes,
So suppose if we decides these writ appeals which we have heard earlier, that this act of 2016 is not applicable in the state of Mizoram, is there any requirement of making further arguments in this?
no, I mean, we challenge this on the ground that if the appeal heard now escapes legal scrutiny, if
No, no.
2016 is accepted, we will lose a good amount of compensation.
We are simply saying that once, let us decide this, whether this act of 2013 is applicable in the state of Mizoram or act of 2016 is applicable in the Mizoram. Your writ petition challenging the validity can be heard in case if we decides that act of 2016 is applicable in the state of Mizoram, then only you can very well argue the matter.
Okay, Lordship.
Otherwise, what is the point in arguing this? Suppose if we hold that it is not applicable, then it is as good as ultra virus or whatever it may be, you can say.
No, my stand is that it's not applicable.
Your stand is as the stand of the counsel for the respondents here.
Yes, yes,
Yes, you are supporting that.
very much.
Then it's okay.
Unfortunately, I feel that he has not, I mean, I am not heard to, what is it? To strengthen his case.
We will decide these petitions after that. है ना? Once we come to the conclusion in this petition, then only we'll consider it.
My lord, will you please just turn the page here in this. Page. Yes, page 11.
Page
Page 11.
11.
Yes. 29.
29. Yes.
Para 8.
Yes.
Para 8.
Yeah.
That the humble petitioner submits that in the article 371G, Roman 4, that is ownership and transfer of land is dealt elaborately in the Mizoram Land Revenue Act 2013 at section 98, subsection 1, 2, 3, 4, and 5. Moreover, the word transfer invariably is subject to the Law of Transfer of Property Act 1882. This transfer of land is, as mentioned in the Mizoram Land Revenue Act 2013, read with Article 371G, Clause 4 of the Constitution, therefore, notwithstanding any law in force, are actually governed and are subject to the Land Transfer of Property Act 1882. Subject to the above mention, it is executable only by way of either an instrument of sale, gift, mortgage, lease, or even by way of wills, and in all cases, it invariably requires registration of the said instruments. This is mandatory because the law of transfer of property under section 54 states that sale of tangible immovable property of the value of rupees 100 and above can be made only by way of registered deed. And let us go through them. Para 9. Para 9. The humble petitioners through counsel again submit that as far as land acquisition and reacquisition is concerned,
গেছে তখন তো অন করুন।
I'm enforcing your case.
How this, so you have challenged the validity of this act of 2016.
Yes, my lord.
You have challenged the validity of act of 2016
Yes, my lord.
by way of writ appeal.
Yes, I have filed a writ appeal.
Why writ appeal? You have to file a writ petition for that.
Oh, no. I have filed writ petition.
Writ petition before.
That
the learned-
was,
learned
that-
single judge.
yeah, learned single judge.
Why? If you have challenged the validity of the rule, you have to file a writ petition before the division bench.
But learned single judge passed an order, no?
Whatever it may be, learned single, there is no jurisdiction, in fact, to look into the matter.
Please read this, let us read, Your Honor, Roman number 2. That is after the index.
So for that purpose, you have to file a separate writ petition, challenging the validity of the order, sir. Then there is no. And again, before the learned single judge, the writ petition is not made available.
Okay.
Even you have not challenged the order of the learned single judge in this writ appeal.
Yes, here in this writ appeal, I challenge the,
Where is that? Where is that prayer?
the prayer is at page 11.
11.
Yes.
Yeah, read the prayer.
In the prayer, Roman number 1, we issue rule in SCA calling upon the respondents why writ mandamus and orders, etc. should not be passed in this instant case. And after hearing both the parties, be gracious to make rules absolute. Roman number 2, to be further pleased to stay all proceedings of land acquisition And to be further pleased to direct the respondents to initiate land acquisition of the land, building and plants, etc. under Act 2023. And be pleased to pass an order that your lordship may deem fit and proper. For end of justice.
So in fact, how this writ appeal is at all maintainable? How this writ appeal is at all maintainable? In para number 11, we have specified that the counsel of humble appellant humbly submits that he has not opted to file an appeal against the impugned judgment dated 6/10/2023 before the division bench at Aizawl. And you have directly come filed this writ appeal here. How can it be? What type of this?
I took the permission.
That is not permissible. Essentially, you have not challenged the order dated 6/10/2023 passed by the learned single judge, and this writ appeal is against which order? Writ appeal is always against the order of the learned single judge.
See,
You have not even prayed for quashing of that order.
what's it? Page 7, please.
Yes,
Page 7, 15,
page,
para 15, page 7, para 15.
yeah, read.
That the counsel for the aggrieved appellant submits that the respondents has been issuing several notifications one after another for acquiring land under Act 2016, which strikes the rule of the learned judge impugned order.
Yes, sir, if you want to challenge the validity of the Act of 2016, withdraw this appeal and seek liberty for that and file separate writ petition for that. We are not going to entertain this challenge of this 2016 in these proceedings. Not at all. How you can challenge in the writ appeal these proceedings, sir? Who was the petitioner before the learned single judge?
Laitham,
Who was the-
Laitham,
Yeah,
Laitham.
and this writ appeal is filed by whom?
Filed by me.
You are the Laithanga.
No, I am the counsel for Laitham.
So this writ appeal is preferred on behalf of whom?
3 persons.
Which 3 persons, sir?
Laitham,
They are the appellants.
yes. Laitham, R.B. Lena and Malcolm Priya. They are the writ appellants in.
Then ask your clients that this writ appeal is not maintainable as such. If you want to challenge the validity of the Act of 2016, file separate writ appeal. This appeal will not serve your purpose.
My lord, may I ask permission to file it here?
File it.
File it here.
You file that there and then make a request. We'll consider it on the administrative side, not on judicial side.
Yes, lordship.
And in concept of the appellant, after attempting to argue the matter for quite some time, has submitted that he wants to, this item number, which is this item number?
10.
10. On instructions has submitted that he wants to withdraw this writ appeal. However, seeks liberty for the appellants to move appropriate move appropriate proceedings before the appropriate forum, challenging the validity of the Act of this 2016 का इसका नाम लिख देना Mizoram Act so and so. Dismissed with liberty as paid for. And this item number 70, 71 and another is?
Item number 5 and 6, my lord, 70 of 2018 and 71 of 2018. Item 5 and 6 are applicable.
These 4 are matters, 2 of the matters 5 and 6, 71 and 70, and what about this 151?
They are represented by my learned friend. My learned friend.
There is my case.
Both these 7 and 8, both?
There is my case, my lord.
7, 8 and 9.
Yes,
and 10.
yes.
And what about 7, 8, and 9?
That is my case, my appeal. This is,
Against the very same judgment of the learned single judge?
yes, dismissing my writ petitions.
The same order which was passed in this earlier writ appeal. Sir, here in these two other appeals or four, कितनी appeal थी? Three other appeals. These are altogether separate proceedings. These proceedings are not related to this item number 70 and 71. Those are separate proceedings, sir.
Yes, this is a writ appeal regarding the
impugned order of the single judge.
वो तो,
But it was-
these proceedings, acquisition proceedings, already completed at the time of 1894 Act was in force.
No, it was acquired illegally in 2010.
But sir, some compensation was granted to.
That is not a compensation, my lord.
Okay, fine, but that was under the old act.
No,
old
no,
Acquisition Act, not
no.
of new act.
It is under, neither under the old act or under the new act. So we are praying to make it under the new act.
What is your prayer? What was your prayer in the Act of 2000, this in the writ petition before the learned single judge? What was your prayer?
Oh, my prayer is here, my confession.
Would you please,
Please turn the page.
page, yes.
Oh, wait. My comprehensive prayer is 3, page 9.
Yeah.
Page 9. There is para number 3.
Read.
The counsel for the humble appellants had furnished and submitted before the learned judge a comprehensive written submission for all the above writ petitions in order to aid and assist the honorable court.
So what was the prayer in the writ petition? We are asking writ petition. What was the prayer in the writ petition?
Writ petition number 1 is to declare the land acquisition of the petitioners in 2010 as null and void in the eye of law.
So it was prior to this coming into force of 2018, 13 Act as well as 2016 Act.
Yes,
You have been paid compensation under the Act of 1894, rightly or wrongly, whatever it may be.
it was not, it cannot be called compensation.
Okay, it was meager compensation, very little compensation.
Oh, yeah,
was
some money was given.
Some money was given.
Yes,
So now you are asking that you are supposed to give some more compensation. That is what your prayer
No,
before
no.
the learned
we are
single judge.
asking for initiating land acquisition under the new act. Since
We'll hear these matters separately, sir, not along with this 70 and appeal number 70 and 71. इनमें ये करते ना, I think है ना, इसमें when you are going to argue the matter?
Lordship, I shall have to go tomorrow. So please give us another court date.
November, this item number 789. 789 this matter for hearing in the month of November. और ये जो 5 number था, 6 number था, 5 and 6 वो हो गया, and एक तो भी है ना, writ appeal number 2/24 वो dismiss हो गया. 70 and 71 arguments are judgment reserved. Appeal number 71 and 70.
Please give us 5th of November.
5th of November.
Thank you,
Yes.
Lordship.
Thank you, Mr. Advocate General. Thank you,
Completely obliged.
sir. Yeah.
Item 11.
Yes.
May it please your lordship. My lord, this writ petition was filed, my lord, against my lord, order dated 22nd November 2018, my lord, passed in OA number 382 of 2016, my lord. My lord, by that order, my lord, if I can go to my lord, the relevant page, my lord, at page 48, my lord. The relevant portion, my lord.
Yes.
May I read, my lord? Para 12, my lord, page 48.
Yeah.
On perusal of the aforesaid decision, we found that the fact and circumstances of the case are exactly similar to the decision relied upon. Learned counsel for the respondents have not been able to produce any contrary decision. We therefore are in agreement with the decision dated 23/10/2018 passed by the Hyderabad bench in OA number 516 of 2014 and series that the clause 3 of the circular number 107 of 2012 is against the provision of IREM, Indian Railway Establishment Manual, discriminative and arbitrary in nature, lack of uniformity, and is in serious violation of the law laid down by the Honorable Supreme Court in regard to seniority and discussed in the said decision. Accordingly, we set aside and quash the clause 3 of the RB 107 of 2012 dated 26/9/2012 and order issued so far based on the said clause 3 will stand invalid. Consequently, the respondent are directed to restore the original seniority of the applicant consequent to the quashing of the clause 3 of the Railway Board Circular number 107 dated 26/9/2012 with consequential benefit manner. This exercise shall be completed as expeditiously as possible, but not later than 3 months already. My lord, thing is that, my lord, the respondents, my lord, pursuant to an advertisement, my lord, applied, my lord, they have applied for, my lord, the post of traffic apprentice, my lord, in the pay scale of 5,500 to 900, my lord. And my lord, after my lord become successful, my lord, they were sent to, my lord, for training, my lord, initial training course for a period of 24 months in 2008, my lord. And my lord, on successful completion, they were, my lord, they worked in, my lord, they joined in working post on 26/4/2010. Now, my lord, what happened, my lord, in between, my lord, the scale of 5,500 to 9,000, my lord, and my lord, and 5,000 to 8,000, my lord, these two scale, my lord, of my lord, 5th CPC were merged in 6th CPC, my lord. These two posts, my lord. And my lord, this, my lord, it is merged, my lord. And thereafter, my lord, this 10, my lord, Lordship may kindly come to page 71, my lord, Annex 3, my lord. My lord, my lord, Roman 3, my lord, of my lord, clause 2, my lord,
Yes.
at page 72, my lord,
Yes.
where recruitment of the post in different pre-revised pay scales were initiated separately for each post prior to acceptance of recommendation of 6 CPC, that is prior to 4/9/2008, but selected individual joined duty on or after 5/9/2008 in the revised pay scale against the posts which have been granted the same grade pay. Such staff will be assigned seniority en bloc below those who were in position as on 4/9/2008, my lord. That means, my lord, whatever the other respondents, my lord, they were in that position, my lord. They were, my lord, in the pay scale of 5,000 to 8,000, my lord.
What about this Hyderabad, the OA judgment?
My lord, that is, my lord, that was stayed, my lord. Lordship may kindly come to, my lord, page 296, my lord, Annexure 20, my lord.
What happened thereafter?
Pending.
It's pending, my lord, still pending,
Still
my lord.
pending.
My lord, now, my lord, the thing is, my lord, the honorable CAT has hold that, my lord, it is against the, my lord, the provision of IREM, my lord. No, my lord, the precise provision of IREM, my lord, I like to, my lord, so, my lord, before your lordship, my lord.
296.
Lordship, yes, my lord. The IRM, the provision of IRM, my lord, at page 126, my lord. Page 126, my lord, Annexure 7, my lord. May I read, my lord?
Yeah.
302. 302 seniority in initial recruitment grade. Unless specifically stated otherwise, the seniority among the incumbents of a post in a grade is governed by the date of appointment to the grade. The grant of pay higher than the initial pay should not, as a rule, confer on a railway servant seniority above those who are already appointed against regular posts. In categories post partially filled up by direct recruitment and partially by promotion, the criteria for determination of seniority should be date of regular promotion after due process in case of promotion, and the date of joining the working post after due process in the case of direct recruit, subject to maintenance of inter-se seniority of promotee and direct recruits among themselves. When the date of entry into grade of promoted railway servants and direct recruits are the same, they should be put in alternative position, the promotee being senior to the direct recruitee, maintaining inter-se seniority of each group. Note 1, my lord. In case the training period of the direct recruits is curtailed in exigencies of service, the date of joining the working post in case of such direct recruit shall be the date he would have normally come to working post after completion of prescribed period of training. So, my lord, what happened, my lord? They have, my lord, joined the actual post, my lord, after training, my lord, in 2010, my lord. Whereas the, my lord, 6 CPC, my lord, modification has come in 2008, my lord. So, my lord, already those persons who are, my lord, working in pay scale of 5,000 to 8,000, my lord, they come to this pay scale of, my lord, 5,500 to 9,000, my lord. And, my lord, this specific provision has been upheld by the Honorable Supreme Court, my lord. The next page, my lord. 302, my lord, I am, my lord. It's a small judgment, my lord. My lord, may I read, my lord?
Yes.
Delay condon. This SLP has been filed against the order of Central Administrative Tribunal Madras Bench on 31/1996 in OA so and so. The admitted position is that the petitioner along with other came to be selected by the internal selection for promotion under 25% quota. Undoubtedly, the process of selection was started in 1988, but incumbents actually joined the promotional post in October 1990. Though the process of selection for direct recruits under 25% quota reserved for the candidates from the open market was started in 1989, they came to join the post after completion of selection process earlier to the petitioner and other in August 1990. The petitioner claimed seniority over them. The tribunal has rejected the claim. Thus, this SLP. the content, it is the contended, it is contended for the petitioner relying upon Rule 302, read with Rule 306 of the Indian Railway Establishment Manual that since the process of selection have been made earlier to the direct recruits, the petitioner is entitled to seniority over the direct recruits since they were selected earlier to the respondents, and therefore they should be made senior to the direct recruits. We find no force in the contention. Rule 302 read as under. My lord, again, my lord, this rule has been, my lord, the Rule 302, seniority in initial recruitment grades, my lord. Unless specifically, my lord, unless specifically stated otherwise, the seniority among the incumbent of a post in a grade is governed by the date of appointment to the grade. The grade, the grant of pay higher than the.
You already read?
Yes, my lord, we have already, my lord. I am skipping that, my lord. Along with the note, my lord. Note was also, my lord,
Yes.
reproduced, my lord, here, my lord.
Taken into
My
consideration.
lord. So, my lord, now the next page, my lord. Similarly, Rule 306 reads as under. 306, candidates selected for appointment at an earlier selection shall be senior to those selected later, irrespective of dates of posting, except in the case of covered by para 305. A reading of the rules would clearly indicate that the process of selection bears no relevance. What is material is determination in the inter se seniority between regularly promoted in-service candidate and those selected by direct recruitment during the process of selection. Is that in the case of the former, the seniority starts from the date on which they join the working post after completion of process, while in case of direct recruits, their inter se seniority would start from the date of their entry into the grade. Therefore, as regard the direct recruits, the date of first entry and joining the post is the criteria. In the case of promotee, it would be the date on which they started working in the post after completion of the process. It is not in dispute that the training is one of the conditions for completion of the process. Until the training is completed, they cannot work on regular basis in the promotional posts. As regard to Rule 306, it regulates in an area where the selected candidates were appointed. Malab, this is regarding to 306, Malab. So, Malab,
So here in the case, the respondents were,
Malab,
here in the case, the respondents were appointed
Malab in 2010, Malab.
after completion of training.
Yes, Malab.
And the persons who were in the gradation list, they were senior to them, placed senior to them, were the direct recruits.
Malab, not there, Malab, already working, Malab, in promotional post, Malab. They are working in the space scale of 5,000 to 9,000, Malab.
Fine.
5,000 to 8,000, I'm sorry, Malab. 5,000 to 8,000, Malab. But Malab, 5,000 to 8,000 and 5,500 to 9,000, Malab. By 6 CPC, it was brought together, Malab. So, Malab, in 2000, Malab, 6 CPC, they came into Malab force, Malab. And Malab, so Malab, on that day, they become eligible for Malab, the pay scale of 5,500 to 9,000, Malab. But Malab, these respondents, Malab, they Malab come into the working post after completion of the training in 2010. So Malab, their seniority were given Malab after this person, Malab.
Below those persons.
Yes, Malab, below those person, Malab. But initially, Malab, there is a hiccup, Malab. They were Malab, their seniority list was published, Malab. They were shown, Malab, the private respondents were shown senior to the others, Malab. But subsequently, Malab, this Malab, which was set aside, Malab, 307, Malab, which was set aside by the Malab line of tribunal, Malab. By that, Malab, the new seniority was drawn, Malab, and the Malab, they were Malab given position after those persons, Malab, who were already Malab posted in those positions.
You have complied with the order of the tribunal.
No, Malab, we have not complied. So, Malab, challenging this position, Malab, we have come with before this. And one more, I would like to, so before your lordship, dear after railway service revised pay rule 2008 was also published, that is in page 129 annex and 9, and page 129, annex and 9,
Yeah.
Reference to railway service revised pay rules 2008 notified by GSR number 643 dated 4/9/2008 and forwarded with railway board endorsement on this one. So lordship may now kindly come to page number 141, 141,
Yes.
The notes, below, notes,
Yeah.
as the post in existing scale of rupees 5,000, this is reiterated, 5,000 to 8,000 and rupees 5,500 to 9,000 in the cadre of specific categories of in the annexer had been placed. The next, three is relevant, the note 3,
Yeah.
in all the other categories cadre except otherwise subsequently specified by Ministry of Railway Board, the post in existing scales of rupees 5,000 to 8,000 and rupees 5,500 to 9,000 and 6,500 to 10,500 in stand merged in grade pay of 4,200 in pay band 2 along with functions, rationalization of function and as also revised designation AVC recruitment rule so and so. So will be issued by the railway board through separate orders. So the railway service revised pay rule was also published, and accordingly, these posts were merged together, and this 5,500, 5,000 to 8,000 and 5,500 to 9,000 were merged, So this is as per the rule also, and there is no violation of the provision of any provision as held by the learned court,
Lordship, there are some gaps in the facts, Lordship. Fact is that, Lordship, employment notice is of 2001. So recruitment year is 2001. Vacancies relate to 2001. So it is a compendium. 15% is for direct recruit. 10% it is under the IREM, Lordship, rules. 15% is for direct recruits. 10% is for LDC, Limited Departmental Competitive Examination. Promotees, they appear in examination and get promoted. Then 75% is for promotee through DPC. Now, Lordship, these pro forma respondents before this honorable court, they are not against the recruitment year 2001. We appeared against the recruitment year of 2001. And I will come to NR Parmar judgment, Lordship. I will come to NR Parmar judgment. No, Lordship, there is another judgment. NR Parmar was protected by Meghachandran. Then thereafter, Lordship, I'd like to appraise Hariharan versus Harshavardhan. Hariharan versus Harshavardhan has come, Lordship. I place the judgment, Lordship. Now, what has happened, Lordship? These people, these pro forma respondent before this honorable court, they do not belong to 2001 recruitment year. They are of subsequent recruitment year. They are not our counterparts. We are already below, en bloc below the promotees of our recruitment year. So we have no agitation against them. And Kota Rota principle, this is a case of this is a case of, Lordship.
Where is the fixation of seniority rules in the
Seniority rules, rule 302, Lordship. Rule.
302 has specified a particular method for fixation of seniority.
It says about inter-se seniority between direct recruits and promotees.
It also says
But-
the interpretation by the Supreme Court. The judgment.
Yes.
So your seniority will be from the date you complete your
Training.
training.
Yes, that,
So now let us, even if it is farmer, even if it is HR, no application because it's a specific rule here.
yes, Lordship, that is there. No, no.
Until
I
the
beg to
training
differ,
is completed,
Lordship.
they
I beg-
cannot work on regular basis on the promotional post. This is what the Supreme Court has said.
No, Lordship, I beg to differ, Lordship. Then I'll
You
rely on
beg
this.
to differ with the Supreme Court judgment, but we
No,
can't
no,
have this
no, no,
luxury,
no,
sir.
no, no, not.
We are not having this luxury. You can differ, we can't.
No, 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 no. Then Lordship, I'll rely on Hariharan versus Harshavardhan. Inter-se seniority will be maintained with regard to the promotees and direct recruits of the recruitment year. Lordship,
It is irrelevant, sir. After this judgment, considering this railway.
Yes.
This,
yeah, Lordship, recruitment
Who
year is
decides?
relevant, Lordship.
now it can't.
302, Lordship. 302 is there, Lordship, but recruitment year is relevant. 302 is silent about the recruitment year.
Sir, here, now come to para number 4 of the judgments.
Yes. Yes. Then I rely on 306 also. 306 also.
Sir, first,
Yes.
para number 4
Para-
of the judgment,
Yes.
read.
A reading of these rules would clearly indicate that the process of selection bears no relevance. What is material in determination of inter-se seniority between regularly promoted in-service candidates and those selected by direct recruitment during the process of selection is that in the case of former, the seniority starts from the date on which they join the working post after completion of the process, while in the case of direct recruits, their inter-se seniority would start from the date of their entry into the grade. Therefore, as regards the direct recruits, the date of first entry and joining the post is the criteria. In the case of the promotee, it would be the date on which they start working in the post after completion of the process. It is not in dispute that training is one of the conditions for completion of the process. Until the training is completed, they cannot work on the regular basis in the promotional post. Now, in 302, Lordship, it is subject to inter-se seniority between direct recruits and promotees. So, inter-se seniority between direct recruits and promotees of which recruitment year? These people, these pro forma respondents are of subsequent recruitment year, much later, Lordship, 2008, Lordship, much later. We are of recruitment year 2001. For a moment, Lordship, may kindly have a look at this Hariharan judgment, Lordship. I have 3 copies, Lordship. Hariharan judgment, para 30, Lordship. Para 30, NR Farmer dealt with, Meghachandran also dealt with, Lordship. 2022 SCC online, SC 1717, para 30. Para 30. Para 30, Lordship, page 38. Page 38. Page 38, para 30. The argument made before us is that the decision in the case of K. Meghachandra will have to be ignored on the ground that it is per incuriam as the attention of the bench which decided the case was not invited to the binding decision of the Constitution bench in the case of Marvin Kotindo and a coordinate bench in the case of M. Subba Reddy. Prima facie, we find substance in the argument that the attention of the bench which decided the case of K. Meghachandra was not invited to the aforesaid binding precedents. Therefore, we are of the view that appropriate course of action would be to refer the question to a larger bench. We are dealing with a case where the rotation of quota or rota and quota system is being followed. If the promotees are recruited in the relevant recruitment year, but the process of recruitment of the direct recruits which commence in the same recruitment year could not be completed in the same year, the direct recruits appointed subsequently will have to be interspaced between the promotees of the same recruitment year. In such a case, it cannot be said that direct recruits were not available during the recruitment year. Here, Lordship, the recruitment year is relevant.
This is the variance. So maybe UPT circulars will be applicable here. To be variance.
But Lordship,
These are all military circulars.
Yes,
Railways have their own circular.
yes,
CCS rules will not apply.
yes. But rules,
Student. So if a railway servant is not covered by the DOT field, how can you bring in those?
then Lordship, Rule 302. Rule 302, Lordship, it says,
Prescribe about quota.
yes, it is there. Inter-se seniority between direct recruits and promotees.
302, the Supreme Court has already interpreted it. Now, is there any scope for further interpretation or take a contrary view from that the Supreme Court has taken?
No, Lordship, here is a
Is this
distinguishing
the,
factor.
this court is empowered to do so, sir?
No, I'm not saying that, Lordship. I am just simply saying that there is a distinguishing factor. Factor is that, Lordship, on the date on which we join the training, after completion of all things, Lordship,
Fine.
appearing in the examination, getting selected, everything, we join the training, Lordship. On that date, Lordship, the pay which we got, 5,500 to 8,000. On that day, these people, Lordship, they were holding lower pay. Lordship will kindly have a look at para 13 of the writ petition. They have admitted that 5,500, 8,000 and 5,500, 9,000 are having different. Lordship,
Yes.
they are having different, Lordship will kindly have a look at para 13 of the writ petition.
Yes.
13. Para 13.
Yeah.
The petitioners beg to state that before implementation of the 6 CPC, the seniority was being maintained separately for different posts in the scale of 5,500, 9,000 and in the scale of 5,000, 8,000. So on the date of our joining training, Lordship, we received 5,500 to 9,000. And these people, either they did not participated in the LDC or they have failed in the LDC of 2001 recruitment year. So they are not our counterparts, Lordship. So we were in the seniority list of 5,500, 9,000. We are in a seniority list of higher grade pay, higher pay scale. And these people, they were in the lower pay scale, Lordship. So we are automatically in the higher pay scale.
Fine.
So in the Kuttian judgment, which my learned friend is relying upon, this scenario was not there, Lordship.
You consider this. Already, sir.
Then I will rely on, Lordship, DR, direct recruit employees, class 2 service also, because, Lordship, then training service has to be counted, Lordship.
Once they, after this Supreme Court, after considering this railway, this regulations, we are supposed to take into consideration that another
But their Lordship,
training period.
but their Lordship, both the class, they belong to the same recruitment year.
Consider you are right, you may be right, but here after interpreting that railway regulation, if the Supreme Court judgment is there, we supposed to take a different view from that.
But then can it be day after tomorrow, Lordship? I'll bring one judgment to the direct
We
recruit
have
employees.
already had you supply the judgments, whatever it may be, we'll wait for you for a day, you supply the judgment, whatever. You just mention the number of the case and supply the judgment, we'll consider.
It's a written argument then.
An argument, you have argued that much of that, please. Citation,
Obliged.
please give the citation, we'll consider.
And during the training, they were getting 5,000 per month, and only after confirmation they have received the
As area we have received.
as area.
So,
Item 12 to 18.
Deeply aware.
May I please, Your Worship,
take
this
some on another.
item may be listed after application.
After that. Another day.
Obliged.
Thank you.